Good, good morning. Uh, Mr. Maxwell, can you hear me? I see you on the screen.
Your Honor, yes, I can hear you.
Thank you very much for confirming. My name is Felicia Orth, hearing officer appointed by the Water Quality Control Commission to conduct a hearing in WQCC 23-84. This is a water reuse rule. We are on the fourth day of hearing. It's 9 a.m. So this is the uh, um, seventh opportunity for public comment, non-technical public comment. There'll be another opportunity at 1 o'clock this afternoon, a ninth opportunity at 9 tomorrow morning, and a 10th opportunity at 1 o'clock tomorrow afternoon. There are just a few guidelines. I have to ask you to stay within 3 minutes, and I will be timing the comment. I have to ask you to collect your thoughts because I can only call on you once. And to the extent you have more to say than can fit inside 3 minutes, please write up whatever you'd like and send it to Pam Jones. You'll find her information the same place you found the information to join us this morning. It can be of any length and will be given the same weight. So I have 7 folks this morning who have reached out to Pam to offer their name. If you're on the platform and have not yet indicated to Pam that you'd like to offer comment, please do that through the chat and we'll get started. Carla Sontag. Carla Sontag.
Good morning, members of the committee. I'm Carla Sontag, President and CEO of the New Mexico Business Coalition.
Okay, hold on 1 second. Do you swear or affirm to tell the truth?
I do.
And if you would spell your first and last name for the transcript.
Yes, Carla, C-A-R-L-A, Sontag, S-O-N-N-T, like Tom, A-G.
All right, thank you. I'll start your time.
Thank you. Water is one of the most important conversations we can have in New Mexico. It is a precious and very limited resource. That is why we must do everything we can to conserve and reuse it however possible. If we don't take steps now to reuse water, we will be leaving future generations in a precarious situation. In working with New Mexico businesses over the past 15 years, water has sometimes been an issue. Sadly, we have lost opportunities for companies to locate in New Mexico because of insufficient water or because of strict rules on its usage. That means our state has lost opportunities for economic diversification and job creation. It would be especially troubling to lose a new company seeking to reuse water in its own operation. If we don't provide the opportunities in New Mexico, companies will and have gone to states that either have more water or better usage rules. We trust that in this rulemaking process, you can develop fair and equitable rules that will ensure the safe reuse of water. If we do this wisely, we can conserve for future generations while allowing our businesses to thrive and create jobs. This is also a great opportunity to create new jobs as we look to a workforce of skilled operators monitoring water usage and everything that goes with that. I encourage you to look for the good of our entire state and all of our people in finding ways to successfully reuse water that would otherwise be wasted. Our limited resources really mandate the wise reuse of water. Thank you for the work you're undertaking and for consideration of my comments.
Thank you, Ms. Sontag. Dan Pritchard. Is Dan Pritchard online?
Yes,
Oh, hello. Mr. Pritchard, do you swear or affirm to tell the truth?
I do.
If you would spell your first and last name for the transcript, please.
First name is spelled D-A-N-I-E-L. Last name Pritchard, P-R-I-T-C-H-A-R-D.
Thank you. I'll start your time.
Good morning, Commissioners, Chairman. My name is Daniel Pritchard, and I live in Taos, and I am on the Executive Board of Renewable Taos, an all-volunteer organization working to promote renewable energy while also protecting the environment and making our community more sustainable. I'm also a state licensed water system operator, and that gives me firsthand knowledge, experience, and responsibility in providing clean, safe drinking water to the 75 residents in my subdivision. My comments today are about responsibility. The New Mexico Environment Department is who we depend upon to protect the waters of our state and set appropriate rules. I support all efforts to prohibit discharge of any produced water outside of the oil field. I was taught that if I made a mess of something, I was responsible to clean it up. The oil and gas industry is accountable and responsible for cleaning up their mess, including spills and discharges of produced water. I urge the Water Quality Control Commission to adopt stringent rules that prohibit discharges of produced water outside of the oil fields and ensure that produced water is safely transported, stored, and disposed of. This can be expensive, but as we all know, the oil and gas industry is making record profits so they can afford it and clean up their own mess. Thank you for your time.
Thank you very much, Mr. Pritchard. Julia Bernal? Julia Bernal? No. All right, if Ms. Bernal rejoins us, I will take her comment. Michael Swearingen?
Yes, thank you.
Oh, hello. Do you swear or affirm to tell the truth?
Yes,
And would you spell your first and last name for the transcript?
Michael, Michael, Swearingen, Sweringen.
Thank you. I'll start your time.
Good morning, Commission members. Thank you for this opportunity to speak. I'm Michael Swearingen. I live in Northwest Albuquerque. I'm a science teacher teaching biology, earth science, and the science of global overheating. Half of all the oil and 2/3 of all the natural gas produced in the United States is produced through fracking. But this also leaves behind millions of gallons of water filled with toxic waste products for each well. How do oil and gas companies get rid of this toxic fracking wastewater, which they call produced water? Our governor has proposed a strategic water supply plan that puts forward one new possibility. Let's try to clean this toxic wastewater and then reuse it. But here's the problem. They don't really know how to clean up this toxic fracking wastewater because they're not exactly sure what's in it. The fracking fluids used to fracture the underground rock are privately owned. They're trade secrets. The oil and gas companies won't share this information. And toxic fracking wastewater can have thousands of different chemicals in it, including forever chemicals, PFAS, benzene, heavy metals like arsenic and lead, and radioactive chemicals. These can cause cancer, birth defects, and early death. Here's what I thought about when I heard about this problem. I'm holding up a bottle of pills. Imagine I have a bottle of red, green, and blue pills, and I tell you, take these. They're safe. Trust me. Of course, you would never take them until you knew exactly what was in them. The oil and gas industry and our governor are doing the exact same thing. They're telling us that we can clean and reuse toxic fracking wastewater, but how do you clean something when you don't even know what's in it? Here are 3 things we should do. Make sure pilot projects, demonstration projects, and industrial projects to clean and reuse fracked water continue to take place in gas and oil fields only, period. Remove this line from the proposed rule, quote unquote, authorization for reuse of produced water in industrial projects, end quote. Because there's no evidence that toxic fracking wastewater, which they call produced water, can be reused safely. There are no science-based safety standards for this. And finally, the big picture, we need to begin the responsible phase out of oil and gas production and to replace oil and gas energy with energy from solar, wind, and energy savings action. Thank you very much.
Thank you, Mr. Swearingen. Stacy Slay. Stacy Slay. If she rejoins us, I'll take her comment. Enedith Lopez. Okay. Can you?
Hi, sorry, I'm here.
Oh, terrific. Do you swear or affirm to, excuse me, do you swear or affirm to tell the truth?
Yes,
And would you spell your first and last name for the transcript?
yes. My first name's Enedith. My last name is Lopez, Lopez.
Thank you. I'll start your time.
Before I actually start my time, can I just address something? I definitely want to address the harm that's caused by the lack of interpretation and language access in this hearing. Members of the community took their day on Monday to attend the hearing to have their voice heard, and they frankly waited until 5 p.m. after the public hearing was limited to 45 minutes, and frankly weren't assisted or allowed to give their comments, which is completely inappropriate. It shouldn't take community members to request giving comments in Spanish. It should be the responsibility of the department to ensure that that is available and accessible. I mean, the state of New Mexico has a large immigrant population, and immigrant justice advocates consistently have to find ways to find language access to ensure that things are being communicated properly. So I really do want to just make it a point that it is the responsibility of NMED to ensure that that is something that's made accessible, regardless if, there's that public notice for 15 days. People who have to work and feed their families and have to go to work don't have the time to make that request. And frankly, that's on the department. But I'm ready now to give my comment if I'm allowed to.
Let me ask just one thing. First, thank you for your comment about simultaneous interpretation. I do understand that there were some folks on the platform on Monday who were frustrated that there was not simultaneous interpretation. I am hoping that the folks who experienced that were informed or came to be informed that we will accept public comment in writing in Spanish and have that translated for the commission prior to their deliberations, well ahead of their deliberations, so that it would come into the record as public comment, be given the same weight. And I hope that folks were informed of that.
Okay, I appreciate that response. But folks were informed of that, and even talking with the administrator, they said that they would be allowed to voice their comment, and that's really where I'm taking an issue with, is that people were not allowed to speak. So the general public, there are folks in the general public who do understand Spanish. I understand the record and the need for the commission to understand it, but community members should still be allowed to speak regardless of whether or not there is that interpretation. But would I be allowed to give my comment now?
Yes. Go ahead. I'll start your time now.
Thank you. Thank you, Chair, members of the Commission, and hearing officer. My name is Enedith Lopez, and I'm the Policy Campaign Manager at Youth United for Climate Crisis Action, also known as YUCCA. Our organization is led by young, Indigenous, and people of color with thousands of supporters across the state. We are deeply committed to fighting for environmental justice, as we see it as our responsibility to honor the longstanding tradition to safeguard our lands and waters, which has been passed down to us by our communities and our ancestors. We have a duty to protect our water, which is sacred, precious, and irreplaceable. We agree that industry must be prohibited from discharging produced water into our ground and surface water, but it is crazy to us that this is something that needs to be established. How dare the industry create this toxic radioactive waste and then threaten to directly poison our waterways with it? But keeping them from dumping it on our crops and plants or dumping it into our waterways is not enough. We must hold them accountable for the toxic radioactive waste they have created. The rule before you totally fails to hold them accountable for their toxic waste. In fact, the rule before you allows industry to take their toxic radioactive waste and experiment with it at the expense of worker safety, at the expense of public health, and at the expense of our environment in their pursuit of profit. How so? Doesn't this rule include requirements for closed loop projects and zero discharge to ground and surface water? It does, but that's not the whole story. This rule includes no scientifically based standards to ensure that workers are protected throughout the treatment, handling, and disposal process. This rule includes no standards for treatment. This rule includes no standards for waste disposal from projects, except the standards already in place under the Oil Conservation Commission, which are already not being enforced, as release of fracking waste takes place daily throughout our state. We have heard affirmed in the testimony by NMED that produced water is toxic and that its toxicity is highly variant and not fully known due to the refusal of the industry to disclose their toxic chemical concoctions. We have heard affirmed that this rule is not setting forth requirements or recite or enforcement through a permitting process for the reuse of produced water for industrial projects. Instead, industry just gets to share their descriptions of their projects and their plans. And if they do so, as long as there's no discharge to ground or surface water, they can proceed. There are no safety protections. There are no environmental protections. Spills and accidents are anticipated in this rule, but there are no minimum standards for financial assurances. A company can take their toxic fracking waste and use it to grow agricultural products in a greenhouse. They could do whatever they want to treat the water. They would just need to describe their plans and the notice of intent. And they could minimize the risk of spills and worker exposure in whatever way they want, so as long as they describe their plans and the notice of intent. The same is true when this rule is used to try and make hydrogen with fracking wastewater. All the companies have to do is describe their plans. This commission is charged with the duty to protect our water, public health, and interests, and the environment. This commission must put safeguards in place based on scientific evidence, because no evidence exists to support the claim that reused produced water is safe, and the Environment Department has failed to include adequate standards. The rule should be rejected, and an alternative rule should be adopted that prohibits all reuse of off the oil fields to ensure the safety and well-being of our communities and the protection of our sacred and precious water. Thank you.
Ms. Lopez,
Yes.
one more thing before I move to the next person. There's a significant possibility that we will not finish the hearing this week, and we'll have to resume at a later date, which would not be next week. I'm not sure when it would be. And with enough notice, obviously, a team of interpreters could be contacted, and I could invite oral comment in Spanish as part of that resumption. Would you please reach out with contact information to Pam Jones so that we can contact you and see if that would be a helpful thing to do when we resume? Okay, I've lost her. Okay, the next person is Ruth Striegel or Striegel.
Yes, that's me.
Oh, hello. Do you swear or affirm to tell the truth?
I do.
And if you would spell your first and last name for the transcript.
Yes, my first name is Ruth, R-U-T-H. My last name is Striegel, S-T-R-I-E-G-E-L.
Thank you. I'll start your time now.
Thank you for the opportunity to speak. My name is Ruth Striegel. I live in Albuquerque, and I serve as the co-chair of the Board of Directors of New Mexico Interfaith Power and Light. I urge the Commission to make sure the rule is crafted in a way that keeps any form of produced water out of our groundwater, surface water, soil, or anywhere that might allow it to contaminate our water or living organisms. Do not allow treated produced water to be used in agriculture. The proposed language is clear on this point and should be retained. To make it very clear what the limits on use are, remove the definitions of use for agriculture, food crop applications, environmental buffers, etc. This section of the proposed rule is inconsistent with the prohibition on discharge and weakens the rule. Our current technology isn't able to lower all the toxins in produced water to safe levels. The use of any form of produced water must be limited to projects within the oil field. Remove the language that allows for its use in industrial projects. We must do all we can to safeguard our precious water, which sustains all life in New Mexico. Releasing treated produced water into our environment would have tragic consequences and must not occur. Our human lives are supported by the complex web of life around us, and if we are to continue existing, we must stop exploiting the earth for profit and live with the realization that we have to respect and live in balance with our environment. Please remove language in the rule on use for agricultural and industrial projects and retain language prohibiting discharge to surface or groundwater. Thank you for your work on behalf of all of us.
Thank you, Ms. Striegel. I don't see anyone in the room I don't recognize, but let me just ask if there's anyone in the room who came to offer public comment this morning.
Good morning, I did.
No. I'm sorry, who spoke?
Good morning, this is Beata Sosi. I had emailed you, but I don't know if it was received.
I'm happy to accept your comment, Ms. Sosi. Do you swear or affirm to tell the truth?
Yes,
And if you would spell your first and last name for the transcript.
Beata, Beata, Sosi, Tsosie.
Thank you. I'll start your 3 minutes now.
Good morning, commissioners and hearing officer. Thank you for this opportunity. I'm the organizational director of Breath of My Heart Birthplace, birth center in traditional Hapo Inga territory. And on behalf of Breath of My Heart Birthplace and our stakeholders, we are very concerned about the rule changes proposing to allow toxic fracking wastewater for uses outside of oil fields. We are concerned about the extremely harmful impacts on our pregnant population, land, water, and communities who rely on New Mexico's waterways and sole source drinking water aquifer. There are devastating health and ecological impacts from fracking waste on our individual and collective reproductive health and rights. Water quality and any attempt at remediating violated waters must center Indigenous pregnant peoples as the standard for environmental protections. Midwives conceived of our communities are keepers of our ways of knowing for matuing all our relations to birth within atgin, respect, sigi, love, rasekane, and embrace of Nanuchukwejo, our earth grandmother, E'opamanu, in the order of the universe. Our ha, our breath of life, our living prayer, is that our children are born rooted in safety, including environmental safety, within our spiritual, cultural, and land-based existence. For too long, Native and land-based families in New Mexico have been dealing with discriminatory policies that have historically been felt by generations as acts of violence on our shared lands and ultimately enabled and perpetuated a culture of violence on our bodies. In order to continue to lay claim to our ancestral places, the suppression of our matrilineal ways of knowing are being replaced with a contaminated existence. This ongoing contamination is of great concern for the future well-being of our children and birthing people in our communities, and is rooted in an ideology that is not indigenous to these lands and does not love or care for us. As midwives and birth workers, we care for and honor our teachings and living in right relations within our cosmology, environment, and in working to maintain balance. Our ancestral lands and waters are a source of strength, active spirituality, and an archive of living memory for how to exist as a part of our ecologies unique to our region. Since time immemorial, we have given birth, prayed, and died in these precious landscapes. Indigenous birthing people must be centered in protections, and we oppose any use of produced fracking waste. We must transition from any economies dependent on the continued destruction of the elements that ensure our collective survival and continuance of our children. Thank you for prohibiting the discharge of reused produced water to surface or groundwater resources. Thank you for the removal of any definitions for uses such as agriculture that are not consistent with this prohibition. Thank you.
Thank you very much, Ms. Sosi. Is there anyone else on the platform who would like to offer public comment at this time? There will be 3 more opportunities. 1 o'clock this afternoon, 9 tomorrow morning, and 1 tomorrow afternoon.
I would like to comment.
And who is this?
India Omega.
All right. Do you swear or affirm to tell the truth?
Yes, I do.
And if you would spell your first and last name for the transcript, please.
It's EYNDIA OMEGA.
Thank you. I'll start your time now.
Good morning. I am a midwife and I serve at Breath of My Heart. I serve prenatal families and take care of them throughout their prenatal care and newborn care as well as postpartum. And I oppose this rule. There is no scientific evidence that this is a safe practice. The risk of birth defects for families, I believe, is inevitable, and no person should be disposing of water off of the oil field. And I'm here just to speak on behalf of families so that their water is protected and Indigenous water is protected.
Thank you very much, Ms. Omega. Anyone else on the platform who would like to offer public comment at this time? The next opportunity is 1 p.m. No? Okay, we will return then to the technical case. And when we interrupted the technical case originally, we were in the middle of the cross-examination of the department. So, no, Mr. Hightower's in San Francisco. He's going to be on Zoom later. So let's go back to the cross-examination of the department. If you would array yourself there at the desk.
Madam Hearing
We
Executive,
had, Mr. Wexler.
I apologize. As they're sort of getting ready, when it's convenient for you, can we discuss scheduling issues? I'm just concerned about some of my witnesses and who have to travel, and so I'm trying to understand when I should have them be here. So whenever it's convenient, I'd appreciate it.
All right, thank you, Mr. Wexler. So NMOGA had completed its cross-examination. Mr. Maxwell had given it a good start, but I don't believe he was finished with his cross-examination. So we will return to Mr. Maxwell. Yes, please, we're going to cover the names first. Go ahead.
Susan Antonia Lucas Kamat, SUSAN space AATONIA. Sorry. What? I'm not done with my last name. 2-word last name, LUCAS space KAMAT.
My name is Jason Herman, JASON HERMAN.
There I go again, early in the morning. My name is Jennifer Fulham, JENNIFER. F is in Frank, U as in umbrella, LL, A as in Adam, M as in Mary. My name is Kathleen Murphy, Kathleen Murphy. You know that.
My name is Leihu, Leihu.
And Teresa, Andrew Knight is the lawyer representing them. And our first cross-examiner is on the platform, Mr. Maxwell.
Thank you, Your Honor. Good morning. Today, I'll continue my cross-examination of Ms. Fulham. Tuesday afternoon, I asked you about the hearing notice you were responsible for posting in this matter. Is that correct?
Yes.
As we left off, I had asked why you chose to apply the State Rules Act's definition of an agency's website to meet the notice requirements for this hearing notice instead of using the definition of Commission's website found in 20.1.6 INMAC, correct?
I believe I recall that question.
At that time, you testified that the department does not have access to the Commission's website. Do you remember that?
Yes.
To clarify, is it specifically your division within the department that does not have access to the Commission's website?
Can you repeat that? I just want to make sure I'm answering clearly.
To clarify, is it specifically your division within the department that does not have access to the Commission's website?
I believe there are other divisions that may not have access to the Commission's website. I'm not sure who has access to edit it.
Does the Water Protection Division have access to the Commission's website?
No.
Isn't the Office of Public Facilitation an office within the Environment Department?
To my knowledge, yes.
Isn't it true that the department's personnel at the Office of Public Facilitation have editorial access to the Commission's website?
I don't believe that's within my knowledge or excuse me, or my testimony.
We'll continue. Now, Ms. Fulham, you testified that posting the hearing notice on the Commission's website is a requirement of 20.1.6 INMAC, and that amendments considered by the Commission must comply with the procedural requirements of 20.1.6 INMAC. Is that correct?
Objection. That calls for a legal conclusion.
Mr. Maxwell, we have to walk this line of not asking technical witnesses for interpretations of the law. So
I
you
believe
can
that.
certainly.
I asked if she testified of that. I think it's a yes
Oh.
or no question.
Okay, so you're right. If it was in her testimony, you can certainly explore it. Do you remember if it was in your testimony, Ms. Fulham?
If he could give me a citation, that would be helpful.
Yeah, we would
But
need
where?
we would need a citation for that statement. I believe it misstates the witness's testimony.
Okay. Mr. Maxwell, can you point us to where she said that?
Okay. One moment. In your direct testimony at page 19, line 7, it starts, amendments must comply with the Water Quality Act, NMSA 1978, section 74-6-6, and 20.1.6 INMAC, which set forth procedural requirements for rulemaking proceedings before the Commission.
Yes, that was in my testimony.
To clarify, under the notice posting requirements of 20.1.6 INMAC, must the hearing notice be posted on the Commission's website and available for public review when it is initially posted?
I believe the language in 20.1.6 9.6, which was entered as an exhibit, has a definition for, actually, I don't know that we provided the definition for provide to the public in our exhibits, but it's my recollection that it does discuss posting the notice on the commission's website.
Ms. Fulham, could you please bring up New Mexico Environment Department's exhibit number 72?
Yes, give me a moment. I have it up.
Is exhibit number 72 a hearing notice for these rulemaking proceedings?
Yes, it's the notice that was published in the New Mexico Register on March 12th, 2024.
Was that 62 days before the hearing?
I believe so.
If this hearing notice, I'm sorry, I'll begin again. Is this hearing notice substantially identical to the one posted on the department's water reuse website page?
I believe it is near identical.
Can you differences between these two notices?
You broke up, Mr. Maxwell.
My question is, can you provide the differences between these two notices?
Thank you.
This notice is directly from the state register, and so the title, the date, would be different because it's specific to the register.
Is the content identical?
Yes.
I wish to direct your attention to the last sentence of the first paragraph of the notice. I will read it aloud and then ask you to confirm if I read it correctly. Are you ready?
Yes.
Please listen carefully. It reads, quote, please visit UQCC website prior to the hearing for at https://www.env.nm.gov/water-quality-control-commission/end quote. Did I read that sentence correctly?
Yes.
Does this sentence indicate that the link I just read is the UCC website?
Yes.
Does the first line of this paragraph use the acronym WQCC to mean the Water Quality Control Commission?
Yes.
Is it accurate to say that the second paragraph of this hearing notice indicates that the proposed regulations can be reviewed online at the WQCC website?
I don't believe so. Oh, let me read further along. The proposed regulations may be reviewed online at the, I'll abbreviate, the Water Quality Control Commission's website.
Is it accurate to say yes or no to that question?
Yes.
Do both the Rules Act and 20.1.6 NMAC require hearing notices to include an internet link providing the public with free access to the full text of the proposed regulations?
Yes.
In your expert opinion, would the full text of the proposed regulations need to be prominently posted at the internet link providing free access in order to meet the procedural requirement of a rulemaking hearing?
The regulations were posted on the Water Quality Control Commission's website under the Water Quality Control Commission's banner under 23-84R. And that was the version that was filed with the commission, and that is what was in the hearing notice. So, yes.
To clarify, is that on the WQCC link page or a different page known as the Docketed Matters website?
believe it's under the WQCC's Docketed Matters website, if I recall correctly.
Are you aware if other boards and commissions also have their matters posted on the Matters website?
Yes.
Were the proposed regulations in this matter ever posted on the WQCC website for public review?
I don't know that they have a website for public review specifically.
Ms. Fulham, can you confirm if the department's water reuse website is located at a different website link than the WQCC website?
It is.
Before we finish with this exhibit, take a moment if you need. Can you confirm if this hearing notice contains any link to the department's water reuse website page?
I don't believe it does.
Ms. Fulham, you've mentioned twice during this hearing, once during your direct examination and once during member Brandcard's questioning, that the notice was posted on the WQCC website on March 26, 2024, 48 days prior to this hearing. Is that correct?
Yes.
Was March 26, 2024 a Tuesday?
I would have to look that up. Did you need me to?
Do you have your phone and can confirm that on your calendar?
I do not.
Objection.
Mr. Maxwell, if you want to make a representation as to what day of the week it was, you can ask her to assume it.
The day of the week was a Tuesday on March 26, 2024. Do you believe that?
I can assume that you have better access to that than I do at this moment.
It is. During your direct, did you testify that this hearing notice was posted on the WQCC website after the department received comments raising the issue of its absence on that page?
Yes.
Are you also aware that in my written comments, I raised the issue of the absence of the full text of the proposed regulations on the WQCC website?
Can you repeat that again? I think there was some interference.
Absolutely. Are you also aware that in my written comments, I raised the issue of the absence of the full text of the proposed regulations on the website, the WQCC website?
I remember that.
You've testified that the hearing notice was posted on the WQCC website on March 26, 2024. Would it also be correct to say that prior to March 26, 2024, there had been no hearing notice on the WQCC website for this rulemaking?
That would be a fair statement.
Were you aware that I sent an email to the department on Sunday, March 24th, specifically addressing the issue of the hearing notice not being posted on the WQCC website?
I was not provided that notice directly, but I believe it was sent to the department on Sunday around midnight or something, and then another one maybe on Monday.
Did you first become aware of the issue on Monday, March 25th or Tuesday, March 26th, 2024?
I can't recall.
Is it accurate to say that the Water Protection Division managed to have the hearing notice posted on the WQCC website within 2 business days of my email being to the department?
We notified the Office of Public Facilitation to let them know of the shortcoming.
I'd like to know more about how that was accomplished. Was the division's request to post the hearing notice on the WQCC website delivered to the personnel at the Office of Public Facilitation via email?
I actually was not a part of that.
Were any of the members of this panel a part of that?
No,
On what day was this request delivered to the Office of Public Facilitation?
again,
Are
I
you
can't
aware?
answer that because I'm not aware.
Is it also true that the hearing notice was emailed to identified stakeholders on March 11th, 2024, which is 63 days for the hearing?
I believe that's in my direct testimony.
It is. Was this email sent to identified stakeholders in order to meet one of the requirements in 20.1.6 NMAC for providing the hearing notice to the public by the 60-day deadline?
I actually believe that we send it to the stakeholders in accordance with the State Rules Act, but it does also coincide with the requirements in the rule of
Are you aware?
20.1.6. I'm sorry.
Are you aware if this notice for this matter was ever emailed to personnel at the Office of Public Facilitation prior to the 60-day deadline?
Can you ask that question again?
Are you aware if this notice for this matter was ever emailed to personnel at the Office of Public Facilitation prior to the 60-day deadline?
I don't think I have that in my testimony, and so I don't know.
Can anybody on this panel testify to that?
No,
You testified that you believe the department did the best job in providing the hearing notice to the public. In light of these timelines we've explored, do you maintain that belief?
yes,
Despite the notice not being posted on the WQCC website by the 60-day deadline, are you testifying that the requirements of 20.1.6 NMAC have still been met because the Water Protection Division of the department lacks access to the WQCC page and has done the best job under these circumstances?
can you break that up into a couple of questions? I
Okay,
apologize.
despite the notice,
It was lengthy.
despite the notice not being posted on the WQCC website by the 60-day deadline, I'm asking if you're testifying if the requirements of 20.16 NMAC have still been met because of two reasons. One, the Water Protection Division of the department lacks access to the WQCC page, and two, has done the best job under these circumstances.
I'm going to caveat the answer to this question because it's an opinion whether we did our best job and whether that meets the requirements of 20.1.6 NMAC. So, do I believe that it was posted on the Office of or on the Water Quality Control Commission's webpage 60 days prior in accordance to 20.1.6 NMAC? No, that statement has been made. Do I believe that the department did their due diligence to put the notice out in all the required places as provided in my direct testimony to our ability and as I testified in my oral testimony? Yes.
Are you aware of the Water Quality Control Commission making any formal designations of its website?
I'm uncertain designations for what?
I'll read the question again. Are you aware of the Water Quality Control Commission recently making any formal designations of its official website?
Again, I'm uncertain. Designations doesn't have a designation of what to who.
Ms. Fulham, you wrote in your testimony that the commission granted this public hearing during their meeting on January 9th, 2024. Is that correct?
Yes.
Did you know that during the same meeting, the Commission adopted a resolution that designated the WQCC website as their, quote, own website, end quote?
I was not aware of that matter. It was outside the scope of my work.
Your Honor, I would now like to introduce an exhibit for identification that I believe will help clarify this matter. This is Maxwell's cross-exam exhibit number 1, the 2024 Open Meetings Act resolution of the Commission, adopted on January 9th, 2020. Ms. Fulham, do you have this in front of you?
No.
I believe you uploaded it into the Dropbox, Mr. Maxwell?
This is correct.
Okay, I'm sorry, you occasionally break up, which is why we have to ask you to repeat things occasionally. Ms. Pam, are you able to pull that up?
I can see the document on the screen. I'll just
Thank you.
lean back a little bit.
Thank you.
Ms. Fulham, have you seen this document before?
I'm familiar that there is one. I have not seen this personally.
I would ask you, but you do not have the copy in front of you. Your Honor, if there's no objection, I request that the Commission take administrative notice of the authenticity of this 2-page resolution signed by Chair Thompson, as it was officially adopted during the open meeting of the Commission on January 9th, 2024.
Yes, that is something the Commission can take administrative notice of.
Thank you,
Let me
Your Honor.
pause. Hold on one second. Let me just pause in the event anyone wants to register an objection. All right, it's in the record.
Near the middle, there is a section boldly labeled Public Notices. Do you see that section?
I can.
Okay, I'm highlighting this area here. In Section A, following the phrase that notices must be, quote, posted prominently on our website, end quote, can you confirm that the link which follows is the same as the one provided in the hearing notice for this matter?
It appears to be.
In the context of this resolution, would you agree that the phrase our website refers to the Water Quality Control Commission's website?
Yes.
Would you then agree that by approving this resolution, the Commission officially recognized the WQCC website as their own website?
Yes.
Your Honor, based on Ms. Fulham's testimony about the Commission's acknowledgement of their official website, I request that Maxwell's cross-exam exhibit number 1, the 2020 Open Meetings Act resolution, be entered into evidence. This resolution, adopted when this public hearing was granted, clearly designates the WQCC website as the Commission's own website. It is crucial to confirm this website as the Commission's official platform for notices, as their procedures mandate posting hearing notices here at least 60 days in advance to validate the rulemaking process.
Yes, I admitted it a few minutes ago. So yes, it is in the record. It's admitted. It can have the designation you gave it.
Your Honor, that concludes my cross-examination of the department's witnesses.
All right, thank you, Mr. Maxwell. We can move then to Ms. Taylor on behalf of Select Water Solutions. Well, we've been going a little less than an hour. You want to get a start? All right.
Good morning.
Good morning. I'm glad to get back to the technical case with you guys. I know you're glad too, maybe. So let's start with notices of intent, the change in the May 6th rule that required 2 new provisions. And so the new provision in 20.6.8.400C2 requires persons implementing demonstration projects or industrial projects. Yes, ma'am. Section 20.6.8.400C2 of the proposed rule requires persons implementing demonstration projects or industrial projects to submit all research results to the department, correct?
Correct.
I believe that Mr. Herman said that that would mean that research results at the end of the process. Is that correct?
Yes,
So are you going to require intermediate results or not? Sounds like not. Is that correct?
that was not the intention of that portion of the regulation.
How would a person applying know that you want just results at the end of the process if the rule doesn't say that?
I would likely rely upon the word results as implicating the end of a project.
Okay, thank you. And I believe that Ms. Murphy testified that the purpose of the rule for notice of intent is to ensure no discharge. Is that correct?
Correct.
So I just have a question about that. How does knowing the amount of constituents, I'm sorry, how does knowing the amount of constituents contribute to the purpose to determine that there will be no discharge?
I don't know that it necessarily does, but it contributes to knowing the final results. You analyze according to the consortium's sampling, and then you test it through the treatment train, and then you analyze the treated produced water, and you test the efficacy of the treatment.
And I would just add that the primary purpose is to ensure no discharge. We do have secondary purposes as well as tertiary purposes associated with our drafting of the rule.
I think this has been discussed before, but the department has not included any regulations or rules about protecting confidential information, proprietary information, or trade secrets, correct?
We have not included any regulations. The Water Quality Act does give us the authority to do that without regulations or promulgate regulations for consideration.
So let me make sure I understand here. So are you saying that you have the ability to protect trade secrets? And I'm just going to use that term generally. You have the ability to protect trade secrets without regulations?
I'm going to ask her to pull up the Water Quality Act so I can read you the exact citation.
Okay.
So that I don't parse it.
Are you looking for the confidential information section? 74-6-15?
I'm sorry, 74-6-1 to 5.
15, I believe.
I don't know that there's a 15. 74-6 dash
15. May I approach?
Thank you. Would you like me to answer a question, or would you like me to read that section out loud?
Well, let's just talk about the section generally.
Sure.
As I read it, and tell me if you read it differently, it says that generally speaking, information submitted under the Water Quality Act shall be public, but it does have an exception for trade secrets and similar items if a person can demonstrate to the commission or the constituent agency that the records, etc., would divulge confidential business records or methods or processes entitled to protection as trade secrets. Is that correct?
It is also followed by some exceptions, and I will note that the department has accepted confidential business information as well as national secrets, and we hold a very high bar, and we also, we hold a very high bar for that determination.
Do you mean that people have to go a long way to prove that it's confidential or should be treated confidentially?
No, I think what I'm saying is that that it takes a considerable amount of evidence for us to be convinced that it's confidential business information that needs to be protected.
I think that's what I asked. I think I asked,
Okay.
does it take a lot for someone to prove to you that it should be confidential, correct?
Yes.
Okay. This statute, as I read it, says that the commission, meaning the Water Quality Control Commission, shall promulgate regulations to implement the provisions of this section, including regulations specifying business records entitled to protection as confidential. That's in section B. Sorry, I should have said that to begin with. So do you agree that that's what the statute says?
Yes.
So has the commission promulgated such regulations?
I can only speak to the ground and surface water protection regulations, which do not include any provisions for confidential business information.
But you're telling me that you have kept them confidential in the past.
As a department.
Okay, what's your authority to do that then?
I believe there is, and I'm not expert and it is also not in my testimony, the Air Quality Bureau has regulations that specifically state confidential business information and they have regulations promulgated through the EIB.
So I think we've heard testimony or suggestions anyway that the lack of protection for confidential information is a damper on industry participating and, fully disclosing their information because of the trade secret issue. How could you help industry understand that they can be protected when there's no regulation? You say there's a very high bar. It seems, I don't know what the standards are. So how can we ensure confidentiality of trade secrets so that you can get the data you want?
Could you rephrase the question? I'm not sure I understand you completely.
Sure. I can remember my question. I I think basically I'm asking, as far as we can see, part of the regulated community, there are no regulations about confidentiality. And that was a concern, especially with the notice of intent issue where people are asked to give all their results. So how can you help industry know that they can get how can you let industry know they can get protection for confidential information if they want to participate in demonstration projects?
I don't know that I have a good answer for you. I don't know that I even have an answer for you.
Would the department be willing to draft such regulations in cooperation with industry?
That's a pretty big ask, but I think Jen would like to respond to that.
If I may, given I generally take some of the lead on.
I'm sorry.
I think I could probably add to that. I think that's a conversation to be had with industry, and we would evaluate each of the NOIs on a case-by-case basis. But for future rulemaking, I don't know that, based on what we read in the Act and based on the concern from industry, that proposed regulations could be proposed by the industry, or there could be some conversations with the department.
Yeah, and I'll just add to the adding that we would not be just ignoring a portion of the Water Quality Act. That if a company came to us and said, we have confidential business information that we would like protected, and we would like to go through the notice of intent process, then we would be willing to work through that process with them. I'm not guaranteeing the company would be happy with our determination at the end of the process, but we would not just toss out 74-6-15 because it's an oil and gas company.
So what I'm hearing is that you're willing to talk to industry, but there's no standards by which industry would know that, yes, this information falls in the category of confidential, or no, it does not. Is that correct?
Yes.
Wouldn't this lack of protection for trade secrets and other proprietary information dissuade companies from investing in produced water treatment projects?
I believe I just said that that lack of existing confidential business information protection does exist. So I don't believe that we would be hampering projects with our actions at this time.
So you don't think it is discouraging people from participating?
I can't speak for them.
Well, there was a comment by NMOGA where they said something to that effect, that it would discourage people from participating. Did you see that comment?
I was in the room. I recall, I believe in the direct testimony from NMOGA, that they stated that, yes.
So would you agree that that's a problem with the regulation as it stands right now?
No, I would not.
Why is that?
I did not write this rule for NMOGA. I'm sorry, we did not write this rule for NMOGA.
But you do want to encourage business innovation and technological advancement, right?
Yes.
And if the lack of protection of trade secrets inhibits that, you're not accomplishing your goals, are you?
As I stated, those protections exist.
I'm sorry, I didn't understand your answer.
The confidential business information protections exist in the Water Quality Act.
But there's no regulations about it.
Objection, asked and answered.
Yeah, you've established that, Ms. Taylor.
So moving to the specifics of the notice of intent provisions, I believe that Mr. Herman testified that NMED has no authority to require submission of all results of demonstration projects. Mr. Herman, that was in your direct on page 33, lines 21 and 22.
I believe that was in reference to our current authority without this regulation in place.
So are you basically asking for that authority here?
Yes.
So on May 6th, with its rebuttal testimony, the department added 2 new NOI requirements: the concentration of water contaminants in the untreated produced water and the quantity of produced water used in the demonstration project or industrial project, correct?
Yes.
So the department did not consider this information to be relevant or necessary for the rulemaking until May 6th, correct?
As I stated in my direct testimony, that was a mistake. I'm sorry, in my rebuttal. In my rebuttal testimony.
So I just want to think about an industrial user, putting aside the demonstration projects, but an industrial user who has a closed loop system with no discharge. Okay.
Yes.
And so my question is that if an industrial user wants to have a no discharge project to use treated produced water, he has to file a notice of intent, prove no discharge, right?
Yes.
And this industrial user or this company anticipates having an industrial process. He's going to set up a factory, and that factory is going to go for years. Okay. How can that industrial user predict the amount of water that he's going to use over the life of that project?
It's a fair question. And it's one we grapple with consistently with our existing notice of intent process. We accept estimates. We accept gallons per day, gallons per year, gallons per hour, total volumes. We will generally work with the person submitting the notice of intent to ensure that we have the information necessary to evaluate the project and its processes.
Very well. And then just one other issue, I think Ms. Murphy talked about a little bit, sort of a 2-step process for a notice of intent in terms of the constituents within the untreated produced water. Or I'm not sure who spoke. That, you know, this was a long time ago when I took these notes. It was like 3 days ago. So I mean, just so forgive me if my notes are wrong. But I think there was a question that if I want to have a demonstration project, not industrial, but demonstration, and I want to use 15 gallons of produced water, I have to tell you what I think is in that water. But in order to tell you, I have to already have an NOI. So can you explain sort of the 2-step process? Is it a preliminary look? And then, I mean, and that's okay. And I'm not violating the NOI, because is my question making sense there? So
yes.
Yes. And I'll see if I can clarify, and Mr. Herman can add on if he feels it's needed. As far as, and Miss Murphy just alluded to it now, the treatment or the raw produced water quality, the treatment train, and then the effluent quality of that. And I believe it might have been me that testified on earlier this week on that. Essentially, there is produced water already being produced in the oil and gas field under OCD. That can be sampled, that can be characterized. That's what you would use to understand what the initial water quality is as required for the NOI.
I see.
So
So
it's not, yeah, go ahead.
So the operator would be testing the water under their authority under OCD.
Correct.
And then say, hey, this is what I have.
Correct.
Now I want to come to you, NMED,
To
and
take
get an
it off.
NOI.
Correct.
Okay, thank you. That's helpful. So I would like to talk now, just shifting gears, a little bit about the rule itself. When did you start drafting the rule?
I will take this question because I was the lead on the drafting. I came in April of 2023 to the Groundwater Quality Bureau, and I began looking at what was left as a real rough draft, and we worked from that. So from April 2023.
So the rule drafting, you don't know if it started in 2019 when the Produced Water Act?
I do not know.
So
And
I do know. So I've been on the project since early 2020, and the drafting of the very first version occurred almost immediately after I got on board. It went through 3 internal major versions before Ms. Fulham received that version in 2023.
So if I could just condense that to say the department in one way or another has been working on this for 4-ish years, right?
In some way, shape, or form, yes.
Okay. And I think this was asked before, but did members of this panel, were you the only drafters
yes,
for the rule that we have
from
today?
2020, April of 2023 on, we were the drafters. It did go through internal editing, but we were the drafters of that rule.
Thank you. Ms. Fulham, in your direct testimony, you said that a piecemeal rulemaking is required because a complete water reuse rule would take numerous years and science would become outdated before the WQCC could adopt a rule.
That is correct.
But don't other rulemakings, like the triennial review, take years?
Yes, and those are amendments. They're not a new rule.
And isn't it common for rules and regulations, including the surface water quality standards, to be frequently updated as scientific knowledge advances?
Yes.
And I understand that the triennial review is for surface waters roughly every 3 years, correct?
Under the federal regulations, the water quality standards are required to be reviewed every 3 years. And this is not in my testimony, but it is in my experience, both with tribal and with state water quality standard triennial reviews that I've held. They take usually about 5 or more years. So we review every 3 years.
But the point is the whole process takes a number of years.
It can.
And for groundwater, just to clarify, there is not a similar requirement to review them every period of time. Right?
There is not.
And so are those reviewed as things change, as science advances?
They are.
So I also think, Ms. Fulham, you have testified that a moratorium is not the directive or intent of the department's petition.
Correct.
But really, isn't that what this rule is, with a complete ban on use of treated produced water? Isn't that a moratorium?
I would disagree that it's a complete ban on the use of produced water.
Explain that.
This rule has provisions for demonstration and industrial projects.
But if someone does a demonstration project and then wants to go forward and actually put that into use, they would have to wait for another rulemaking, correct?
Incorrect.
Incorrect?
Yes, a use is not necessarily descriptive of whether it's discharging or not discharging. There is a prohibition on discharges as proposed in this rule. There is not a ban on the use of produced water, however.
But if and I presume you're alluding to industrial projects, is that correct?
Demonstration and industrial projects.
But if a industry member wants to use produced water, say to provide public water, as Mr. Hightower described yesterday, that particular use of treated produced water would take a new rulemaking.
Correct.
And those rulemakings could take years.
It could. It depends on who the petitioner is.
What do you mean by that?
Under the Water Quality Act, any person can petition the commission for amendment to the rule.
So how could a petitioner shorten the time to get a rule? I don't understand.
If they have more resources and they have the data and they meet all the requirements of the acts for noticing and petitioning, it could take up to a certain amount of time. It's dependent on the evidence that's being presented, the extensiveness of the petition. Just like this rule is only 7 pages, but is taking a considerable amount of time, whereas a triennial review that we just did took 4.5 days worth of testimony for the review. So it's really dependent on the complexity of the petitioner's argument. And so if it's just adding or subtracting and it's straightforward, the petitioner could have a simple petition, but there's still the regulatory requirements which take time.
So, Mr. Herman, I think you have testified that neither the Water Quality Act nor the Produced Water Act includes any language authorizing the Commission to adopt regulations that strictly prohibit the use of treated produced water outside the oil and gas industry.
Thank you. I believe in my testimony that is within the context of the permitting regulations of 20.6.2 in the 3000s.
But doesn't this rule, initial rule, strictly prohibit the use of treated produced water outside the oil and gas industry?
No, it does not.
Because of the reasons Ms. Fulham just explained?
Yes.
Because you can have an industrial project, a no discharge project, or a demonstration. So that change to the rule to go from getting a permit under standards to a ban in the March rule, the amendment in March, what I'm talking about, that shifted the rule to be a ban except for demonstration and industrial projects. Why did you make that change?
I can probably speak to that as I provided in one of my testimonies. It's either my rebuttal or my oral testimony. So as I've stated, all the information that the department has put out since 2019 was that we would have a restrictive rule that would allow for demonstration projects so that we could get more information to develop standards as we would think to be applicable or treatable. When we did the public comment, there was only demonstration projects, which were non-discharging. When we filed with the commission, there was a typographical error when we put in industrial. We inadvertently put in the word application, which would be contrary to the rest of that section in 400, because it implies a discharge that would require a discharge permit. When we found that essentially when we were drafting our written testimony to it and realized that's what had made it into the version that was petitioned before the commission. And that, I believe I state that in believe it's in my rebuttal or my oral testimony.
So the permit provision that was in the rule before essentially was a mistake?
It was contrary to the language that was in section 400A, which said that there wouldn't be any allowable discharges. So it created an implementation issue. We can't say that there is a prohibition for discharges and then the next paragraph allow for a definition for a defined term that would require a discharge permit. So we needed to rectify that discrepancy.
And so the provision that you had in the earlier rule, and I'll be more specific in the December
Thank you.
rule, that talks about effluent and in effluent standards.
Which version of the rule are you referring to?
I believe the December version, NMED 71.
Okay, I believe that would be the public comment version.
Exhibit 71, I believe, is the petition for rulemaking and statement of reasons.
Yes, 71 was the version that was filed with the petition.
So thought that one had the discharge, or I'm sorry, effluent standards in it. Effluent quality, yes. It's at 20.6.8.400 D on NMED 001901, and it has effluent quality. So was that a mistake too?
As I stated in my rebuttal, in my oral testimony, I believe on Monday, I described the iterations of section 400D and how it started out from until such a time that there are effluent standards. Then it was amended to be simpler because there was duplication. And then it was the department who determined that this was adding confusion based on comments that we had received. And so now it's being removed entirely to not imply that there are any effluent quality that would be sufficient for use in applications.
And so let me make sure I understand. So earlier you said that you made the changes because you realized that you had a drafting error that didn't comport with the rest of the rule or the intent of the rule.
Are you speaking to the industrial applications?
Pardon me?
Are you speaking to the industrial applications?
No, I'm just talking about generally, I mean, earlier, in the earlier iterations of the rule, a permittee could get a permit to discharge treated produced water.
Objection, that misstates the witness's testimony.
Yeah. Ms. Fulham, can you address that in a way that's accurate?
The department did not have a draft rule at any time that allowed for a discharge permit or discharge of produced water.
Of treated produced, I've just treated produced water.
Treated or untreated.
Again, I'm looking at NMED Exhibit 71 under 400A2, where it says treated produced water discharged to surface water. And I'll paraphrase. It says, no person shall cause or allow treated produced water to discharge to surface water unless the discharger has obtained a permit approved by the department. It sounds like to me someone could get a discharge permit.
Correct, but I believe in the effluent quality, it states that there wouldn't be one. It says discharges of untreated produced water to surface or groundwaters of the state are prohibited.
Yes, ma'am, that does say for untreated, but I'm looking at A2 that says treated produced water. And it says you can discharge it if you get a permit.
Objection, that's not what it says.
Ms. Taylor, let's stick more closely to the language in the
Sure.
draft rule.
It says that no person shall cause or allow treated produced water to discharge to a surface water unless the discharger has obtained a discharge permit approved by the department.
Correct.
Okay, so the effluent quality in D on the next page that prohibits the discharge of untreated produced water is for untreated produced water, not treated produced water, correct?
That is what that says.
Okay, so at this point in this December rule, iteration of the rule, someone could have gotten a permit to discharge treated produced water.
There was language that implied that they could.
I think it more than implied it. I think it said that.
Objection. She's stating her opinion and not asking a question.
Right.
I'll move on. But I still, I think the basic question I have is, so that rule provides for a potential permit to discharge treated produced water, correct?
It implies that there would be the opportunity to submit an application for a plan that
Yes.
would be protective of groundwater.
And then in March, the rule was changed to be a ban of discharge of treated produced water, correct?
I will add that it aligned closer to the public draft version and then provided that prohibition.
What is the public draft version? I'm sorry.
I believe it was submitted as NMED.
Is that the public comment
exhibit-
version?
Yes, NMED Exhibit 49.
And what I'm looking at is Exhibit 49, NMED page 001619, which basically is 400A3.
Okay.
And that says, no person shall cause or allow treated produced water to discharge so that it may move directly or indirectly into groundwater. I'm sorry, that's the wrong one. We'll just stick with surface water here. So A1. On that one does say that the surface, that in accordance with this part, a produced water discharge of surface water is prohibited.
Right.
If I could just clarify, it was never, in my understanding, the department's intention to allow for discharge of treated or untreated produced water to any surface waters or groundwaters of the state.
In that particular public comment rule, let's call it Exhibit 49 for discharges to groundwater, which is A3, that does say, and I'll read it, that no person shall cause or allow treated produced water to discharge so that it may move directly or indirectly into groundwater unless the discharger has obtained a discharge permit approved by the department.
It continues on to say until such a time that water quality criteria based on scientifically defensible information about the composition, toxicity, fate, and transport of treated produced water is adopted by the Commission, the department shall not approve a discharge plan or a discharge plan modification that includes the discharge of treated produced water.
Correct, but that does imply, in your words, the ability to eventually get a permit, correct?
Until the Commission adopts criteria, there would be no discharge plan or discharge permit or
But when-
discharge plan modification that includes discharge.
But once the standards are set, a permit could be obtained. Correct?
Yes.
Okay.
We're coming close to the time when we need a break. Ms. Taylor, would you find a good time?
This is fine.
All right, let's take 10 minutes.
Your Honor, this is Mr. Maxwell. I'd like to know if there should be part of there.
Can you hear me?
I can hear you.
Okay, good. I have some of the parties here, not all of them. Okay. Uh, and they wanted to understand our basic strategy for going forward. And so the statement that I made before I turned on the microphone was that I would very much like to complete the cross-examination of the department panel before we do anything else other than public comment at 1, which we have to do. And I don't know how long that's going to take, but we need to finish it. After that is done, if Mr. Hightower is available, I'd like to go back to him. And then we'll go to Mr. DeSalen. Right. So anyway, juggling as hard as I can. Okay.
That's what we're asking to do.
Oh no, I thought, let's see. Right. Hold on. I have to go backwards. NMED, Amigos Bravos, NEE, WEG, Hightower, Center for Biological. Yeah, okay. Yeah.
So it might
Yeah,
be today or tomorrow morning.
it just depends on when we finish the department cross, and if when we reach out to him, he can actually leap on Zoom or sorry, WebEx.
And then the other question I have is, can for my examination of both who and Hightower, can I ask Ms. Jones to pull something up on the screen?
Yeah. So yeah, if it's in Dropbox, hold on one second. Pam, would you confirm that if it's in Dropbox, you're able to share screen? Okay, so probably the best thing to do is to warn her.
Well, what if I
Give her some
email
warning.
you?
You should have been sent a link.
Yeah.
Pam said she sent you.
I sent the email yesterday. I didn't get it.
And I checked both my email addresses. I got it.
Okay, good.
Okay, we'll make sure you have access to the Dropbox. Okay, so the best thing is to give her some warning. All right. Okay,
Outside of Dropbox.
great. All right. All right, we are back after a short break. Ms. Taylor is questioning the department panel. Sure. Are you recording? You are. All right. Go ahead, Ms. Taylor.
Thank you. I just want to understand the process and then we can move on of the iterations in the drafting. So the public comment draft had a prohibition on surface water discharges. Correct?
Correct.
And then you took public comments.
Correct.
And then the next draft was the December draft that was the petition to the commission for the rulemaking.
Correct.
And that version of the regulation added the possibility of discharge permits if water quality standards were set.
It implied such, yes.
And then you waited 2 months then to file an amended petition in March. And that amended petition removed the language that had the possibility of a permit, right?
Correct.
And it also removed the statements about setting water quality standards, correct?
Correct.
And then the last iteration of the rule was May 6th as your a rebuttal exhibit, correct?
Correct.
And that added the NOI provisions about quantity and constituents for demonstration industrial projects, correct?
Correct.
And I think you testified that that was a crucial provision of the rule now, correct?
I'm uncertain that we use the word crucial, but
In your rebuttal on page 22, lines 16 through 18, Ms. Fulham, I believe you stated that this addition about concentrations and the quantity of produced water is, quote, crucial to the protection of human health and the environment under the state's Water Quality Act, unquote.
I will take your quote.
But you said it's crucial, but it wasn't crucial until this month, correct?
Incorrect.
So let's move on from the process of the rulemaking. And let's talk about New Mexico's need for water. And you have said, Ms. Fulham, I believe, in your direct testimony, that the state needs to expand its water portfolio so that potable water is not, quote, used for everything, unquote.
I believe so, yes.
And I believe you also said that climate change is anticipated to reduce the state's available water supply while water demand is increasing.
I recall that, yes.
And I think you have already testified at this hearing that, or this rulemaking, that 95 of the 407 active groundwater discharge permits authorize effluent reuse.
Correct.
And would you agree that produced water that is shown to be protective of New Mexico's surface waters could be reused to supplement water deliveries to Texas on the Pecos and the Rio Grande?
I can't speak to that.
Why not?
Because I have not been given evidence that it is protective.
But let's assume that it is protective.
I don't know that I can.
Well, just for the sake of my hypothetical, please assume that the discharge would be protective of surface waters. Okay.
I believe you're asking for an assumption that's not based on any evidence in the record right now.
Okay. And are you familiar with the permit that has been issued in Texas for discharge of treated produced water into surface water?
No.
Have you seen Mr. McCurdy's rebuttal testimony?
Yes.
And he discusses or mentions that permit, correct?
I believe he mentions it, but I am not familiar with it.
So he has testified on a different topic that treated produced water can be treated to an ultra pure quality required for green hydrogen production. Required for green hydrogen production. Are you familiar with that?
I
generally?
recall reading that, yes.
Okay. And so if or when that's the case, under the proposed rule, no discharge permit could be issued for a green hydrogen project until a rulemaking is held to repeal the ban on the discharge of produced water. Correct?
If there was a discharge required, correct.
And so that could take years before the green hydrogen project could start, right?
If there was technology, that I would hope that we would petition the commission and get that in place.
But that process could take a few years.
Could, yes.
So I have another question. So let's say that the green hydrogen project uses treated produced water, but the treated produced water will not be discharged. Is that project then an industrial project? It's a closed loop system.
I'd like to clarify, closed loop is not necessarily non-discharging.
Okay, well, I'm sorry. Let me just rephrase that to say that it's non-discharge under the definition of 20.6.8.7 I3 or 1.3.
I'd like to pull up the
Sure.
definition for industrial project under the rule that we're currently proposing before the commission.
It's on NMED Exhibit 175 at 004573.
I have that.
Okay.
So as we have proposed in NMED Exhibit 175, industrial project means a reuse water project that does not discharge and that is used in connection with industrial processes such as alternative energy, hydrogen production, cooling water, process boiler feeds, utility power plants, chemical plants, and metal working facilities where at a minimum, public access is restricted or limited. So to answer your question regarding hydrogen production, that is part of the industrial project definition.
Thank you. And so that project then would be subject to the NOI requirements. Is that correct?
Correct.
And is that true even if the green hydrogen production process does not itself treat produced water, but only uses produced water?
Correct.
And that would, the beginning of that project or the initiation of that industrial project would not begin until they got an NOI determination of no discharge, correct?
Correct. Which at this point usually takes between 30 and 60 days.
Oh, thank you for that clarification. And I just want to just ask one more question about that supplementing the surface waters of the state of New Mexico with treated produced water. But if it is shown that it could be protective of surface and groundwater, then could it be used to supplement water deliveries to Texas?
I don't believe that the Environment Department oversees water rights or could speak to whether that could be supplemental to Texas.
Well, putting that aside though, I'm just talking about if the water could be shown to be protective of surface waters, could it receive a discharge permit to supplement surface waters?
Again, I believe that that's an assumption that the department can't make at this time.
Okay, so let's move on to the fact that, at least my understanding is that the NMED has never banned any particular source of water before.
Can you clarify what you mean by ban?
Sure. In the May 6th version of the rule before the commission now, the discharge of treated produced water is prohibited. And so I believe you've heard testimony and you have had testimony that you need this ban because there's a quote unquote loophole in the regulations that somehow, I think what you mean is that a treated produced water could be discharged if this rule is not put in place.
I believe that's my testimony specifically. And I do not believe that I stated that a discharge permit would be issued, but I stated that we would have to grapple with drafting a discharge permit, which at some point.
Senator Shelby Joe and Director Kayla Hartman are live to talk about delivering the motherload of big screen comedies.
I wish I could rely upon that answer. I'm gonna get my. Can we start over?
Sure.
Can you restate?
Oh,
the
can I start
question?
over?
Yes.
Sure. As I understand it, the loophole issue that you have identified is that unless you have this regulation as proposed, that you could be forced to issue a discharge permit for treated produced water.
Okay, thank you. I believe my testimony stated that we would have to grapple with drafting a discharge permit. Issuance is where we kind of get in trouble with the framing of your question. It's not my determination as to whether or not a permit is issued. It would go through a public notice process. And then, but I do agree that we would, as the Groundwater Quality Bureau Pollution Prevention Section, be required to process an application through the public notice process and then work through the drafting process.
And I think you've said that that allowing discharge, no, I'm sorry. And some other source waters for permitted discharge contain organic and inorganic metals, materials, salts, metals, oil, volatile and semi-volatile organic compounds, naturally occurring radioactive materials or norms, PFAS, and or chemical additives used in industrial or other processes. Correct? I believe that was Dr. Hu.
Yes, I have this statement in my testimony.
In some other source waters for currently permitted surface water discharges contain or may contain emerging contaminants. In some treated discharge water contain or may contain emerging contaminants. Correct?
Can you clarify whose testimony that was in again?
Let me see.
Thank you.
I believe that was Ms. Kamat.
Can you give me a reference, please?
You know what? I cannot at this point. I apologize. So, Ms. Kamat, how many NPDES permits have been issued in New Mexico?
Can you clarify on a time frame, please?
Sure. Last 3 years.
So EPA has around 90 to 100 individual permits issued in the state of New Mexico and 5 general permits issued in the state of New Mexico.
And as you just mentioned, they're issued by EPA, but the department must certify in the Section 401 certification process that they comply with New Mexico's surface water quality standards.
Correct.
And also, new surface water discharges undergo an anti-degradation analysis by the department before they're approved, correct?
Correct. All new discharges have to undergo an anti-degradation process before EPA will issue a draft permit.
And based on that analysis in its Section 401 certification, the department can set effluent limits for a discharge.
Correct.
And has the department ever denied Section 401 certification solely based on the source of the discharge?
To my knowledge, no.
And so you contend that there is a loophole in the Section 401 certification process that must be closed because the department cannot deny certification based solely on the source of the water.
Correct.
But NMED is not required to certify discharges of treated produced water, correct?
Can you rephrase the question or restate the question, please?
Sure. NMED is not required right now to certify discharges of treated produced water.
Correct.
And NMED can deny certification if the treated water fails to meet New Mexico's water quality standards, just like any other treated discharge, correct?
Can you repeat the question too?
Sure. NMED can deny certification if the treated produced water fails to meet New Mexico's water quality standards, just like any other treated discharge.
Correct.
And that applies whether the other treated discharge is from industrial processes or wastewater treatment plants. Correct?
Correct.
So really there's no loophole to be closed, is there?
The loophole is that we do not have water quality standards right now to address treated produced water. And so having the prohibition will provide us a regulatory standing in a 401 certification denial.
So you're saying the department wants the authority to deny certification without doing really its job to confirm that the water does or does not meet applicable water quality standards?
No, what I'm saying is that there are unknown chemicals in treated produced water that we may not have standards for. And while we do have the anti-degradation process, if a constituent is not in the anti-degradation, we may not be able to protect the receiving waters. And so we want the ability to deny 401 certification.
And that's based on the fact that there are unknown constituents in the wastewater?
It's based on the fact that we don't have a complete characterization of produced water to perform a complete anti-degradation analysis based on the water quality standards. Water quality standards? Right.
But you don't have a complete characterization of municipal wastewater either, do you?
We have a much better understanding of the pollutants that are in municipal wastewater?
But not a complete understanding.
No, not complete.
And you don't have a complete understanding of industrial discharges either, do you?
We do not know everything that is in an industrial discharge, but in industrial discharges, we tend to know the process and what's gone in.
But you issue discharges permits for those types of waters, don't you?
We issue 401 certifications for those types of water.
I'm sorry. Yes, you were correct. It's a 401 certification. But so it's really because of the fact that it's treated produced water, you want to say, we're not going to issue any 401 certifications.
Correct.
But you have that authority already, don't you?
We do have that authority because the department has not denied a permit, denied a 401 certification. We need to have supporting evidence in the 401 certifications. So for example, if our 401 certification conditions a permit, I have to have something in 20.6.4, 20.6.2, or any other regulation. And to deny a permit, I would need the same regulatory basis.
So let's move to a slightly different question. So let's say that a potential discharger of treated produced water recycles the produced water and learns from its customers the constituents of everything that went into that produced water, knows the frac chemicals, all the other things and has the information on the source water. And then the recycler then designs a treatment train technology or technologies to treat those specific constituents and has pre-treatment and post-treatment. And then therefore the recycler can analyze the recycler can analyze the untreated produced water to determine the constituents in the feedstock and the treated produced water. They know the whole process. The results show that the treated produced water reliably meets the New Mexico drinking water standards.
What is the question?
I'm getting to that.
Okay.
But for the ban or the prohibition on discharge of treated produced water, why can't that water be permitted for discharge?
Are you asking specific for surface water or for groundwater or for both?
Let's take them one at a time. Surface water, since you're on.
So for surface water, the reason we would not issue a 401 certification is meeting drinking water standards is not meeting surface water quality standards. They are different standards.
Well, let's change my hypothetical to say that they meet all the water quality standards. Why couldn't you issue a surface water discharge permit?
If I may, for both.
Sure.
I've reviewed the record of the 1973 hearing where the original 3103 standards were promulgated, and those standards in that regulation were specifically promulgated and excluded oil and gas waste in their considerations. They only considered domestic and industrial wastewaters. And so those numbers, the numerical standards, as well as the future toxic pollutants narrative standard, were not considered, were not drafted, argued, and promulgated specifically. They were specifically promulgated and excluded oil and gas waste from their analysis during that promulgation.
I can't do math. So that's a 50-year-old ruling proceeding before the commission.
Sure. I'm sorry. I've also reviewed the 1982 toxic pollutants, where they made the same exclusion, as well as the revisions that occurred after the Supreme Court of New Mexico argued and upheld portions of the toxic pollutants that were then returned to WQCC for revision. And there was also revisions in 1992, which I have not reviewed as extensively, but do also include the same caveats, I believe.
So you're just relying on the history of the regulations.
I'm saying that the numbers that we have and the standards that you're asking about their applicability here were specifically promulgated and analyzed to exclude oil and gas waste.
But what if all of the pollutants were removed? What if I ended up with a distilled water process that is oxygen and hydrogen? Could I not get a permit for that?
I can answer to that.
Sure.
We would have considerable reservations for discharging distilled water based on the removal of all the minerals in there. It makes it a highly aggressive water and it leaches out. So it would actually cause a problem as well.
And I just want to add that issuing a discharge permit doesn't just consider the water quality. It considers the reliability. It considers the permittees or the applicant's ability to maintain that water quality over long term. It considers what level of monitoring is required in order to ensure that happens. And we do not have that additional information at this time in order to write those types of regulations for these processes.
Write regulations or write permits?
Both.
Just one more addition to my hypothetical. Let's say I don't have distilled water that the process ends up with. but just purified water. Still has the minerals, still has good stuff, tastes good. Why couldn't a permit be issued for that?
Again, I would like to refrain from trying to project into the future. Based on the information that was available to NMED, we've developed the petitioned rule to be protective of ground and surface water.
This is a different topic. Do all surface and groundwater discharges permitted by the department result from anthropogenic activity?
So specific to the MPDS permits and the 401 certification, MPDS covers stormwater discharges. Stormwater discharges do not necessarily result from anthropogenic activities.
Other than stormwater discharges, do the other surface water discharges result from anthropogenic activity for surface water?
It's a big question with some nuanced complexity to it. I can say generally the vast majority, if not a very high percentage in the plus 90%, if not plus 95%, yes, anthropogenic.
Thank you. So we've talked about surface water permits. Let's move to groundwater permits. So roughly in the last 3 to 5 years, how many groundwater discharge permits have been issued in New Mexico?
I don't believe that's in my testimony, but I am the section manager and I will speak for the pollution prevention section, which issues industrial and domestic wastewater as well as reuse permits currently. We have 463 active permits currently that rotate on a 5-year basis. And so we, on average, will permit issue around 90 to 100 permits, mostly renewals, some new, many modifications. Per
And
year.
has,
Sorry,
excuse me, sorry, did you finish?
per year,
Can you just condense that and give that to me in a sentence?
about 100 per year.
Thank you. Has the department ever denied a groundwater discharge permit application on the sole basis of the source of the discharge?
No, not that I am aware of.
And that's because the department looks at the water quality of the discharge itself to ensure it meets groundwater standards, correct?
Amongst other things.
Among other things?
Yes.
Is whether it meets groundwater standards the primary criteria?
I'd like to answer this as the reuse team lead and have Mr. Herman in the more general sense. For reuse water, when we permit reuse water, it is critical. Oh, that's okay. I will try. I will speak as the reuse team lead and then refer to Mr. Herman in a more general sense for permits. When applications for the discharge of reuse come in, the department does review and has to review the source water to ensure that there's sufficient treatment so that the water quality. So when we review wastewater treatment plants, they come in with plans and specs that say that they can remove, and we have to ensure that we have to know the source in order to know what type of treatment, to know what kind of effluent quality they will consistently meet. And for reuse, that is critical.
And I was asking more generally about groundwater permits. Generally, does that apply also to groundwater permits generally, looking at the source to know how the treatment is successful in meeting water quality standards?
Generally, that is one of the aspects that would be looking at. You mentioned a couple of the others, the treatment process, as well as, yes. But I would say that there's multiple primary things that we look at.
But remains, I think we have said that you've never denied a groundwater discharge permit based solely on the source. Correct?
So I think I'll take this in the direction that I'm comfortable with because I'm not aware of the full history of every permit. There's 2 other sections that issue permits. So I feel a little uncomfortable wading into that pool. But I will say that the Water Quality Act does set out the exact provisions that we have the authority to deny a permit under. And source water is not one of those.
Yes, sir. That anticipates my next question, that no existing regulation authorized the department to deny a discharge permit on the basis of the source or type of the water being discharged.
Yes.
And again, so there's no loophole to be closed. The department simply wishes for the first time to deny a discharge application based solely on the source water, even if the discharge meets existing surface or groundwater standards, correct?
I would disagree with that statement,
What part?
that there is not a loophole.
You believe there is?
Yes.
So what you're saying is that excuse me. So what you're saying is you want separate standards for treated produced water based solely on the source of the water and not the quality of the treated water.
Can you repeat the question? I think I understand it, but I'd like to better understand it.
So what you're saying is you want separate standards for treated produced water based solely on the source of the water and not the quality of the treated water.
So we've shifted to a different phrasing, which then actually moves us out of what I was testifying to earlier, or my response earlier. We do have provisions in our regulations that are specific to types of discharge. We have domestic wastewater discharge requirements, industrial wastewater discharge requirements that must be met in order for us to, in order for the secretary to approve or issue a discharge permit. And so, no, I'm not asking for something special here. I'm asking for the tools necessary in order to accomplish the same type of process that is codified already in 20.6.2 for domestic and industrial waste discharges, in this case for untreated or for treated produced water.
I think you've also testified, Mr. Herman, that the department agrees that it's unclear whether the Water Quality Act authorizes the prohibition of the use of a specific water type when the use does not threaten ground or surface water.
It sounds like me, but if you could provide me with a citation to agree.
It was in your rebuttal at page 15, lines 12 through 14, and page 16 at lines 7 through 9.
Was that a quote?
It's certainly a close paraphrase of the quote. Yes, sir.
I'm sorry, what page again?
So page 50, your rebuttal, page 15, lines 12 through 14, and page 16, lines 7 through 9.
Okay, so it looks like it's my response. First, it is unclear if the suggested changes are authorized by the Water Quality Act and if the department can prohibit a single application of a specific water type when that specific use does not threaten ground or surface waters. That's the language. I'm sorry, what was the question associated with that language?
I wanted to make sure that's what you had said.
Yes.
And so my question is to follow. If the Water Quality Act does not authorize a prohibition of discharges based on source, then what authority does the commission have to adopt this rule?
I would likely look to the Produced Water Act.
Yeah, I'm going to object. That calls for a legal conclusion.
Right. Ms. Taylor, we're walking the usual line.
All right, so let's move to a different topic. And I want to understand for produced water demonstration projects and industrial projects and the rule as it relates to groundwater and surface water. There's a difference in how the May 6 rule treats surface water and groundwater in demonstration projects and industrial projects. So could you confirm that any produced water demonstration project or industrial project authorized by the department under the proposed water reuse rule will not discharge in a manner that may directly or indirectly affect ground or surface water and will not pose any risk to water quality? I think Dr. Hu spoke to that as well as Ms. Kalmat. Ms. Kalmat?
Can you provide the citation for Dr. Who?
Yes, I can. For Dr. Hu, it was rebuttal at page 3, lines 4 through 6, and Kalmat rebuttal at 13, lines 14 through 17. The language is that the rule, quote, provides a very narrow path for the safe use of produced water for limited, highly controlled situations for research purposes.
I found the citation. Could you please repeat the question for me?
I just wanted to confirm that that's what your testimony says.
Yes.
So if there is no discharge from these projects, then the WQCC has no jurisdiction to ban them, correct?
No, the Water Quality Act specifically states, the Water Quality Act specifically states that any rule or regulation may include a prohibition on discharge if necessary.
But I think the Water Quality Act and Produced Water Act also says that the commission has no authority to regulate activities that do not threaten ground or surface water. The proposed rule authorizes limited, controlled, safe, closed-loop industrial projects.
I believe the Water Quality Act says that in order to be protective, that prohibition may be necessary.
So such water demonstration projects are important for the development of new or improved technologies to clean up produced water to levels that would allow the reuse of treated produced water outside of the oil and gas field to supplement the state's water supplies, correct?
I think I got lost on the on-ramp. Can you restate that one?
I'll break it down. Are demonstration projects important to allow the development of new technologies to treat produced water?
I believe they can be.
And the authorization for non-discharging demonstration projects or industrial projects is contained in the discharge to groundwater subsection, which is 20.6.8.400A4.
Did you say authorization?
Yes, ma'am. That was in Ms. Kamat's rebuttal
Yes.
at 13.3.16.
Correct.
And so the proposed rule filed with the December 27th petition said in that section that demonstration projects and industrial projects, the proposed rule filed with the December 27th petition said in the section concerning treated produced water discharges to surface water demonstration project and industrial applications related to surface waters submitted to the department through the notice of intent process are authorized to operate following the determination of no discharge permit required by the department. Is that correct?
I guess, may I ask some clarifying question?
Sure.
So the department proposed the May 6th revision of the rule, and the iterations of back and forth have been getting a little bit confusing because that's not what the department's petitioning for. So I guess maybe if you could phrase that in a way that's relative to the May 6th version, that would be helpful for
Sure.
us.
Let me just get to the point here.
Okay.
So the amended petition filed March 20th. And this part has not changed in the May 6th rule. Remove the language in subsection A2 concerning treated produced water discharge to surface water while retaining it in subsection A4 concerning treated produced water discharge to groundwater.
Right.
That's the difference I'm asking about.
That's helpful.
So here's my ultimate question. Are the demonstration projects and industrial projects restricted to research related to the ultimate discharge of produced water to groundwater?
We're both trying to answer no.
I think we're both going to say no.
Okay. And so I accept your answer as no, meaning that demonstration projects could ultimately show the way to allow a discharge to surface water. Correct?
Absolutely.
Okay.
Correct.
Given that background or that sort of understanding of the intent, isn't the proposed language confusing because it only refers to demonstration projects regarding groundwater and not surface water?
Sorry, we had the wrong version up and
I get that a lot.
I'm gonna give you a point. I do see how that could be confusing. The intention of the department was not to restrict demonstration projects to simply final disposition in groundwater. It was to allow for demonstration projects that are researching or looking at any manner of items. I would point that an industrial project would not involve surface water. Correct. But I don't know that's really a valuable clarification here.
Are you saying I got something right?
Yes.
Okay, let's make sure that gets on the record. Well, would you agree then that the language needs to be added back into the surface water discharge section?
I would argue that that's speaking to the future, and at this point, I think that the rule as we've proposed still stands.
Even though it's confusing, you don't want to change it or propose to the commission that they
It's
change it?
assuming that it will go to surface water at some point in the future. So demonstration projects really at this point are focused on groundwater impacts. So I think adding language to the surface water aspect, and I will let Miss Lucas come up to speak to that.
And so to add to what Ms. Fulham said, it's not a future prohibition. Like it could be, well, it's that right now none of the demonstration projects have any surface water component for reuse. Yes,
I think we would just simply state that we support the language as written and that we don't believe that the clarification is warranted.
So I'm not right?
I apologize.
Well, I mean, I think uh, you said earlier that language is confusing.
I believe I said that it could be construed as confusing or interpreted as confusing, yes.
What's the basis for that distinction between ground and surface water?
Can you be more specific? The distinction in 1, 2, 3, and 4?
The distinction.
Less.
So demonstration projects are in the rule now are looking toward groundwater, ultimate groundwater discharges. Demonstrations projects addressing surface water don't have the same language.
I think your question is couched in the idea that you're wrong, but I still think you're partially right. That, and I'll give you the reason it really is in the groundwater portion is a historical reason. If you look at the notice of intent process in 20.6.2, notices of intent are submitted to the Groundwater Quality Bureau chief, and the Groundwater Quality Bureau is the main processor of discharge permit notices of intent. And so we had something going there that we liked and carried that over into this process as well.
I'm sorry, could you just repeat that last part? I just couldn't hear it.
We were used to the process that exists in 20.6.2, and so we mirrored that in the proposed regulation.
So one more topic, and then we all get to go to lunch. Time flies when you're having fun, right?
Yes, it does.
So economic costs. Would the department agree that economic benefits or costs are not a relevant consideration when determining whether a discharge permit should be issued? Mr. Herman, I think you have testified to that.
Yes. Yes.
So you would agree with that statement that benefits or costs are not relevant in issuing a discharge permit?
I would like, if you have a citation, to understand the context that I testified to that within.
Sure. It was your rebuttal at page 14, line 21, 22. And I think a paraphrase of that quote is that the department rarely considers economic benefits or costs to be a valid evaluation tool.
So yeah, the modifier that's important there is rarely. I believe that we do at times consider it, but it is not common.
Thank you. That concludes my cross-examination.
Thank you, Ms. Taylor. We still have a little bit of time before we'll break for lunch. Mr. Cox, do you have questions of the department panel?
I do, Madam Hearing Examiner, just a few.
Thank you.
Just a moment here. This is just for the panel generally. In the proposed rules, is there any limit to the size of an industrial project?
I can answer that. No.
Thank you. And I'm just gonna ask a few questions about notice. Not the notice of this rulemaking, but the notice related to the NOIs. For the notice of intent process, is any public notice required?
As written, the proposed regulations do not have any notice requirements associated with them.
Thank you. So the applicant's not required to publish anything in a local newspaper or anything like that for a notice of intent for an industrial or demonstration project?
So in our regulations, the term applicant has a very specific meaning, and I would maybe prefer to say that someone submitting a produced water NOI is not required to do those things.
Okay. So hypothetically, if a company is going to build an industrial reuse project next to where I live, I'd have no notice of that. Is that correct?
Not as it pertains to the notice of intent for using produced water in a non-discharging manner.
Right. And I heard earlier, I believe you testified that currently the department is posting these NOIs to their webpage. Is that correct?
Yes.
And when does the department post the NOI relative to when they receive it?
Probably within a couple days.
And so is it being posted, before it's approved or afterwards?
When the NOI is submitted, I post it. We review it, and when we issue the no discharge permit required letter, then that's posted.
Okay. So it's after the determination that no discharge is required, no discharge permit is required?
Can you say that again?
So I'm just trying to make sure I hear what you're saying, that it's you publish you post the NOI on your webpage after making the determination that no discharge permit is required. Is that correct?
No, it's a work in progress. When they submit an NOI, I put that on the webpage. And then it's probably within 2 months of a review, and then we issue all applicable documents we put on the webpage. So for example, if we require more information, I also post that.
Okay, thank you. But that's not posting, that posting is not required by the rules currently, is that correct? The proposed rules?
That is correct.
And is there any public comment opportunity for notices of intent for industrial or demonstration projects?
No, there is not.
And is there any public hearing opportunity for notices of intent for industrial or demonstration projects?
No, the notice of intent process is designed for us to make a determination as to whether or not we would have regulatory authority over that project. So a hearing would have to be scoped in whether or not we had authority. The hearing would be held on whether or not we had authority over that activity.
All right.
I'm not supposed to, but I'm taking your question and running a hypothetical in my head.
Sure. No, I just want to work through this, how this might work. If a member of the public, let's say me, there's a industrial project going in next door. If I disagree with the department's, I don't want to say approval, because if I disagree with the department's issuance of a no discharge permit required in response to an NOI, is there any way for me to challenge that decision?
Absolutely. Our regulations have a provision that state any determination or decision made by the Secretary of the Environment may be appealed to the WQCC.
And how long do I have to file that appeal?
30 days.
And how will I know to file that appeal without a public notice?
I was going to make a snarky comment, but I'm not going to because this is serious and you would not.
Okay. So thank you. Yeah, I think that's.
Hold on. Kathleen Murphy has an addition to that.
Okay.
I believe in the NOI, it states that the neighbors need to be noticed.
Where does it state that?
One moment.
No, I'm sorry. That's in our attachment B in our current process.
So that's attachment B in the current process,
Yeah.
but not in the proposed rules. Is that correct?
Correct.
And what does that notice look like currently in attachment B?
We're going to pull the exhibit up real quick so we can make sure we're accurate and correct with our response.
Sorry about that. Thank you for your patience. Currently, we do have demonstration projects as people have testified to so far, and they're required to, or we ask them to submit a notice of intent with additional information that's required in what we call attachment B. That can be found in NMOGA Exhibit 29, and it starts on page 11.
All right, but that's not required by the proposed rules, correct?
Correct.
Okay, thank you. I'd like to move on to my second and final topic. And I'd like to talk a little bit about the Canales project. And I believe Mr. Herman spoke about this issue a little bit on Tuesday, so my initial question is going to be directed at you, Mr. Herman, but again, I welcome answers from the panel. Mr. Herman, you stated that there was some concern that the Canales project had resulted in produced water being discharged. Is that correct?
So no, there's three aspects of the company Canales in all of the testimony and exhibits. There is an event that occurred prior to any project. There is the first pilot project, and there is the proposed second pilot project. The initial event, I think, is what you are referring to, that we went and inspected with the Oil Conservation Division.
Okay, so that's you're referring to that as the initial event.
Sure, I'd like that. Yeah.
And there was a concern that there had been some potential discharge as part of that initial event related to Canales. Is that correct?
It was reported. It was reported to us that a discharge of treated produced water had occurred.
Okay. And the question was whether the treated produced water had been applied to some grasses that were just on the ground. Is that correct?
Correct.
And you stated, I think on Tuesday, that some sampling was done in response to this concern?
The Oil Conservation Division did, yes, sampling, soil sampling.
And that, as a result of that sampling, you determined that treated produced water had not been discharged?
I did not make that determination. The Oil Conservation Division did.
And that sampling was conducted by Interra Geosciences and Engineering. Is that correct?
Yes.
I'd like to take a look at that report. I'm not sure the best way to share it since I'm remotely. I submitted it as Center Exhibit 7. I uploaded it to the Dropbox earlier today, but I also filed it on May 6th. Ms. Jones, what's the best way for us to talk about this?
We have it. We have it up on our screen.
Council, you can share your screen if you'd like. You're on the platform.
Okay. Yeah, but you also have it there, Mr. Herman?
And I mean, it's Center for Biological Diversity Exhibit 7?
Yes.
Yes.
Pam just made you a presenter, Mr. Cox, so you can share your screen.
Great, thank you. that showing up?
Yes, it is.
Okay. So I had too many PDFs open.
I think you're going to want to hit the plus sign, though. It's very hard to read.
Okay. Is that any better?
That is better. Thank you.
Great. Thank you. So, Mr. Herman, are you familiar with this report from Intera?
It has been a long time since I reviewed it, but yes.
And this is the sampling report for the soil at Canales. Is that correct?
Yes.
And regarding whether produced water was discharged at Canales, was any other sampling or analysis conducted beyond this report?
Not that I'm aware of.
Okay. So to your knowledge, this study is the sole basis of OCD's determination that treated produced water was not applied to soil at Canales.
I cannot speak to what OCD utilized in their determination.
Okay. But you're relying on OCD's determination.
I can only speak to NMED's determination that the activity occurred on or within the Oil Conservation Division's jurisdiction and not the Environment Department's jurisdiction.
Okay. But when you stated on Tuesday that treated produced water was not discharged, what were you relying on for that statement?
The communication from the Oil Conservation Division that was their determination.
Okay. I'd just like to take a look at this report. If we scroll down to the bottom of what's the second page, which would be marked Center 17, the Bates label, I've highlighted here on the screen. Maybe we can zoom in a little more. Oh, too much. So can you see that final paragraph on center 17 and the top of center 18, Mr. Herman?
Yes.
Could you read that for me, please?
These results, relative to background levels, suggest irrigation of the raised bed with a source other than untreated produced water. To identify the source of the water used for irrigation with some certainty, a comparison of geochemistry data produced from this investigation with data collected from potential irrigation water sources, coupled with an evaluation of data concerning the volumes and periods of application are necessary. Data revealing the extent of filtration would be necessary to determine if the water used for irrigation derived from treated produced water.
Thank you. So would you agree that based on this report, they've determined that untreated produced water was not discharged, or was not applied to those beds? Is that accurate?
I believe that Intera is the author of this report, and that would be Intera's determination.
Yes, but you agreed that that's Intera's determination that untreated produced water was not discharged here?
Yes.
And that Intera doesn't know if treated produced water was discharged. Is that also correct reading of this paragraph?
Yes.
And to your knowledge, this is the report. This is the analysis that was done to determine whether produced water, treated or untreated, was discharged at Canales.
Yes.
And has OCD, in your conversations with them that you've based your testimony on Tuesday on, did they reveal that they had done, that they had more data revealing the extent of the filtration, or that they had, collected data from potential irrigation sources coupled with an evaluation of data concerning the volumes and periods of application?
The only recollection I have is they had conversations with the on-site manager as well as the on-site manager's son, I believe.
Okay. Well, thank you, Mr. Herman. I don't have any further questions. And that concludes my cross-examination.
Thank you very much, Mr. Cox. You can stop sharing then. We have just about 6 minutes. Is Mr. Hightower on the platform? I have reason to believe he's not. All right, he would be next in cross-examination. Mr. Davis, will you have cross-examination of the department panel? Can you just go for about 6 minutes? Thank you.
Good morning. I'm going to try to be not as loud as yesterday. Oh, you do? Okay. I can oblige. I'm going to go through just one quick topic and then stop and check in with you, Madam Hearing Officer. If you don't mind turning to NMED Exhibit 175, I believe that is the most current version of the proposed rule. Is that correct?
That is correct.
I'd specifically like to ask you about section 20.6.8.400B2.
Very specific. Thank you.
That section reads, no person shall cause or allow treated produced water to discharge. So, sorry, that's A2.
Yeah. Got lost for a second.
Yep. The demonstration project or industrial project shall be designed to provide information specific to untreated produced water quality, treatment technologies, treated produced water quality, treatment volumes, and toxicity studies for potential produced water reuse applications. Did I read that correctly?
Yes.
Let's have a few questions about what parameters are required to be included for treated produced water quality. So the question is, what parameters are required to be included for treated produced water quality under that provision?
Describe parameters, I guess. That can mean a lot in the scientific world.
Sure. Are there any standards that are required for treated produced water quality reporting under that provision?
There's nothing specified as far as the constituents, the particular constituents they would provide. The information that we would get or not get from this will be or will not be used to determine whether we can develop standards.
Who would decide what the standards are or what is reported?
There's two different questions there. What the
Sure, take
standards
one at a
are.
time. Yeah, who would decide what the standards are under that provision?
There are no standards.
Who would decide what is reported under that provision?
There is no reporting under this provision. It's part of the notice of intent at the initial.
Who would decide the design of
The entity.
being the project proponent?
Correct.
Okay, thank you. Would this require the reporting, or would this require any toxicity studies to be performed for a pilot project?
Does not require that.
Does it require an analysis of treatment volumes?
It does require in another section the volumes that they're proposing to use.
Does it require characterization of produced water samples for the project?
State that again.
Would this provision require characterization of the produced water sample?
It does say that it should be designed to provide information specific to untreated produced water quality. It doesn't prescribe what parameters would be in that water quality analysis.
And so those parameters would be decided by the project proponent.
Correct.
This is a good.
I would just like to add that we go through an iterative process with these submissions, and so the department would be a collaborator on that. We wouldn't assert authority over it generally, but we could, and we could make that a condition of a no discharge permit determination.
So I'm trying to think about how this would play out. The project proponent would submit a design plan. The department would then potentially give input on that.
It would come through the form of a request for additional information. I love my hypotheticals that I'm not supposed to give. We get an NOI that they say we are only going to characterize TDS, and we're going to run this project in this manner. The department would likely push back and say, we cannot make a determination based off of that limited amount of information.
Under your hypothetical, if the project proponent did not take the department's input into consideration, could the department deny the NOI request?
Under the proposed regulations, yes.
And what provision in the proposed regulation would permit that?
That would lead us to a discharge permit required determination, and therefore, I mean, yeah, I walked myself down this one, didn't I?
So if you don't mind, I'm just gonna elaborate a little bit on what Mr. Herman was saying. These notices of intent that get submitted are reviewed by the department personnel, and those are the personnel and the scientific staff that you have before you today. We do work with industry regularly on these demonstration projects. They have a need to try and learn the characterization, potential treatment options, and then what their effluent quality is. So although it may not necessarily be required under this regulation, it is something that we would work with them for, because the ultimate goal for industry is to learn whether they can or cannot treat produced water. And so to answer your question, it may not be specified or prescribed here, but it is in the best interest of the department and industry in order to get the information if they were to want standards to be adopted in the future. Hopefully that didn't look like it clarified it for you.
I think simply stated, my question is whether there's anything in the proposed rule that would allow the department to deny a notice of intent based on the design plan that we've been discussing since I began my questions a few minutes ago.
So a denial would look identical to silence from the department. Silence. Sorry, that we would not issue a no discharge permit required, and there is a provision within the regulations that says that they may not go forward with the demonstration project until they have received a no discharge permit required determination from the department.
Is this a good place to stop, Mr. Davis?
Yes.
All right. Let's come back at 1 for public comment. Good afternoon. My name is Felicia Orth. I'm a hearing officer appointed by the Water Quality Control Commission to conduct a hearing in WQCC 23-84. This is a water reuse rule. We have come to the 8th of the opportunities for public comment. There are 2 more opportunities tomorrow. Please mute yourselves if you're on the platform. Thank you. This is, again, the 8th of the 10 opportunities this week to offer public comment. We accept public comment from those in the room and also those on the platform. If you have not already reached out to Pam Jones to indicate that you want to offer public comment, please do so that I know to call on you. Just a couple of guidelines. Comment is taken under oath or affirmation. Comment is limited to 1 comment each and limited to 3 minutes. If you have more to say, please submit it in writing to Pam Jones anytime before the record closes. Certainly anytime this week would be within time. So let me start with the names that I have. Reverend Ryan Tate. Reverend Tate, are you on the platform? You may unmute yourself. No? All right. If Reverend Tate rejoins us, I'm happy to take his comment. Leanna Derrick. All right. Are they able to unmute themselves, Pam? All right. Christina Castro. Christina Castro. No? Oh, I see Joan Brown. Sister, will you unmute yourself?
Yes, I'm here.
Oh, terrific. Do you swear or affirm to tell the truth?
I do.
Thank you. And would you spell both of your names for the transcript?
Joan, Joan, Brown, Brown.
All right. Thank you. I'm going to start your 3 minutes now.
Okay. Thank you, Water Quality Commission and Hearing Officer, for this opportunity to speak at this water reuse hearing. I am a Franciscan sister and Executive Director of New Mexico and El Paso Interfaith Power and Light. And we work with faith congregations and people of faith and or conscience all over the state. Many of our people are very concerned about water, and water is sacred in all traditions. We have an ethical and moral responsibility to not make sister water part of a prevalent mentality that Pope Francis names our throwaway culture. We need to be extremely careful in addressing water use and water quality in New Mexico. In ethical terms, the concerns of communities and our responsibility to and with sister water and future generations must be held as important and high priorities. Often such issues and hearings weigh heavily upon narrowly defined economic interests that bend toward the arc of industry rather than the arc of justice. In a recent teaching document, Laudato Deum, Pope Francis helps people of conscience with a critique of our extreme cultural bias of a technological worldview. While we do need technology, we also need to hold in esteem the meaning of being human and our purpose on the planet, which is to live in community with everyone and everything, giving dignity and rights to all. Paragraph 21 of that document states that an exaggerated reference to technology and power places the power in the hands of a few and does not serve the whole. Quote, everything that exists ceases to be a gift for which we should be thankful, esteem, and cherish, and instead becomes a slave or prey to any whim of the human mind and its capacities. So I believe this critique is important as we are hearing these rules, and IPL is very grateful for this hearing. We would like to make 3 points. 1, please prohibit the discharge of reused produced water to surface or groundwater, whether it's cleaned or uncleaned. The current rule states this, and we strongly agree with this piece of the rule. Number 2, please remove the definitions that are not relevant to this matter of rulemaking, such as agriculture, environmental buffers, food crop application, and words that are not consistent to the prohibition of use of produced waters. Number 3, remove language for use of reused produced water for industrial projects, or limit the only use directly in the oil field. Currently, there's really not scientific data that shows that technology that currently exists can reduce toxic chemicals in produced water to safe levels, and even trace levels are harmful to health. And we're quite concerned because this cannot be undone once it is done. We are also concerned about waste products and their disposal, which includes from the current, what I call experiments being done with produced water, and also the daily disposal of produced water in the oil and gas field. But we realize that is not the context or subject of this hearing, but we wanted to express that concerns. So I just want to thank you again for your considerations and your discernment for the Sacred Trust over the next days and weeks.
Thank you very much. Julia Bernal. Ms. Bernal,
Yes, can you hear me?
speak up a little bit.
Okay, can you hear me now?
Yes.
Okay, great.
Do you swear or affirm to tell the truth?
Yes.
Would you spell your first and last name for the transcript?
Juliabernal.
Thank you. I'll start your 3 minutes now.
Thank you. Good afternoon, commissioners. I'm the executive director of Pueblo Action Alliance. I've been with our organization for going on 8 years, but have been involved in water resources for about a decade as a student at UNM, as a previous water resources technician, but also culturally, as I am a tribal member of Sandia Pueblo. My family has been farming and stewarding, and even in governmental positions have been protecting our lands for generations. And central to our culture is water, whether in the form of rain, rivers, groundwater, or clouds. Understanding that our Pueblo communities have the most senior water rights, so we should be an important stakeholder in this discussion. But I wanted to share that I have researched impacts to the reuse of produced water off oil fields. And for example, in the state of Pennsylvania, oil and gas operators were permitted to take their oil and gas waste to specific wastewater treatment facilities to then have that treated effluent put back into the tributary systems. It has had long-lasting impacts where it's been found that the points of these outfalls are where elevated activities of radium in the stream sediment have occurred, and even more so in the past few years, even after the discharges have stopped. And so this is an important example because this is waste that was coming only from conventional drilling sites, because the state, the Pennsylvania Department of Environmental Protection, they had prohibited oil and gas waste from unconventional drilling to these specific permitted facilities because of high saline discharge. And so if we look at the San Juan Basin and Permian Basin, they have all adopted unconventional drilling. And what we fear that this rule could do is potentially open the door for a one-size-fits-all rule that doesn't consider these long-term cumulative impacts. And I know the state is wanting to see how this treated oil and gas waste can be used for green hydrogen, but hydrogen and produced water reuse off the oil field are pilot programs, and what I'm hearing are trial technologies that haven't been proven at scale. So, we have to ask ourselves, are we going to continue this historic legacy of experimentation or using our sacred lands and waters as testing sites? Because so many people benefit from the diversity of land-based, traditional, and indigenous cultures in New Mexico. And if we're going to continuously impact land and water, we will not have these traditional lifeways in the future. We will cease to exist as the first people of this land. And so our organization urges the commission to think deeply about the environmental, public health, and cultural impacts this type of initiative can have on New Mexico and its communities. Thank you.
Thank you very much. You hit 3 minutes just perfectly there. Stacy Slay. Stacy Slay.
Hello.
Oh, hello. Do you swear or affirm to tell the truth?
I do.
If you would spell your first and last name for the transcript.
STACIESLAY.
Thank you. I'll start your 3 minutes now.
And thank you, Commission, for letting me give this comment today. I support a clear, straightforward prohibition against the discharge of untreated and treated produced water to ground and surface water. A prohibition on the discharge of produced water is necessary because there is insufficient scientific evidence demonstrating that produced water can be treated to New Mexico water quality standards that protect the public and the environment. Industry proposals to weaken the prohibition and allow discharge of treated produced water should be rejected. Authorization for reuse of produced water in industrial projects should be removed from the rule. Industrial projects which are not volume or time limited in the proposed rule carry increased risk of contamination of ground and surface water through spills, accident, and inadvertent discharge to public water systems. There is insufficient evidence in the record that ongoing use of produced water is in an industrial setting is even safe. I have serious concerns that the industrial projects will further entrench the oil and gas industry in New Mexico at a time when our top priority should be transitioning to clean and sustainable energy alternatives to protect our climate, watersheds, and communities. Unnecessary definitions in the proposed rule should be removed. Many definitions are unnecessary because they are not included in the body of the rule and therefore serve no regulatory purpose. Definitions such as agricultural application and food crop application imply the rule permits discharge of produced water to land, which it does not. The unnecessary definitions of various land applications can lead to public confusion that the rule is not a prohibition on discharge to land. The rule should require NMED to publish notices of intent, NOIs, for demonstration projects on the agency's website, including projects approved and rejected. If the spills of treated produced water during if there are spills of treated produced water during the demonstration projects, NMED should promptly and effectively take enforcement action against the violators and require immediate corrective action and cleanup. Thank you very much for your time. I appreciate this opportunity.
Thank you very much. Emily Tucker?
Yes, hi.
Emily Hello. Do you swear or affirm to tell the truth?
I do.
Please spell your first and last name for the transcript.
EMILYTUCKER.
Thank you. I'll start your 3 minutes now.
Hi, yeah, thank you for the opportunity to make public comment. My name is Emily Tucker. I'm a resident of Albuquerque and an organizer with the nonprofit Food and Water Watch, and I urge you to reject the proposed water rule that the Water Quality Control Commission is hearing today. This rule is a dangerous proposition that puts all New Mexicans at risk by treating toxic fracking waste and using it for other purposes outside the oil field, industrial production, even agricultural uses. Some might try to spin this rule by calling it produced water, but you cannot produce water. This is oil and gas waste, plain and simple. Even after the treatment process, the waste product remains now in a highly concentrated form that still needs to be disposed of. Furthermore, as others have said, there have been no peer-reviewed studies that prove the treatment process makes the resulting liquid safe to begin with, and experimenting with using oil and gas waste outside the oil field gambles with the safety of our communities, our workers, our water, and our land. The ongoing drought and water crisis is one of the most challenging issues our state must face in our lifetime, but this is clearly a false solution that will only worsen the crisis and ignores the root causes of it. We need real solutions that hold industries accountable for their excessive water use and contamination. And we need to hold the oil and gas companies accountable for poisoning our communities, but this rule does neither. In fact, it further entrenches the industry in New Mexico while rolling the dice with the health and safety of our communities. The industry might call it produced water, they might say it's water reuse, but I want to call it what it really is, which is experimenting with toxic radioactive waste that endangers our state's water and puts our communities at risk. So I urge you to protect New Mexicans, our land, and our water by rejecting the water reuse rule before us today. Thank you.
Thank you. Alejandra Lyons.
I'm here.
Oh, terrific. Do you swear or affirm to tell the truth?
I swear and affirm to tell the truth.
Would you spell your first and last name for the transcripts?
Yes. ALEJANDRIALYONS.
Thank you. I'll start your 3 minutes now.
Thank you. Yes, my name is Alejandria Lyons. Thank you, Commission and Chair, for holding this hearing. I'm Alejandria. I am the coordinator for New Mexico No Fault Solutions. I hold a master's degree in community and regional planning. I previously was, interested in a master's of water resource. I held a position at the Albuquerque-Bernalillo County Water Protection Advisory Board. And I'm also, I grew up in Bernalillo County, semi-agricultural community, and we hold water rights in Peralta. And so I'm here to preserve the integrity and water quality for future generations, not only through my position with New Mexico No Fault Solutions, but also as a water protector. There's a notion in the state that we need to put water to beneficial use, but I believe that's only true if your only concern is money and your only concern is to continue this boondoggle, which is prolonging fossil fuels and the waste that comes with it. We are in a drought and we need to do something about our water, but we can't negate how much of our water is being destroyed by such operations, our air, our land, our water. On average, oil and gas industry spills are radioactive and they happen quite frequently. In the Permian alone in 2022, those that were recorded was over 30,000 spills. So, I mean, I think that is quite a bit. And for every barrel of oil produced, approximately 4 barrels of waste is generated. I think that the state is trying to solve the oil and gases issue for them, their waste problem. And as many people have pointed out, this rule would allow for this toxic waste to go from the oil fields. And we are upset with the ways that this would allow industrial and demonstration projects for treatment and the disposal of these with no scientific evidence of how the handling, the disposal of these radioactive substances. And so I think we urge the Water Quality Commission to look at the science, to look at what this rule and what you would be approving if you were to move forward with this rule. Because if we look at what the governor is trying to do with the strategic water supply, we are seeing that, we are in this issue where we are trying to make something happen. But really what we need to do is look at the entire fuel chain of oil and gas. And, there's been a lot of talk of hydrogen and the hydrogen economy. And our coalition believes that this is an effort to get this off the ground because they didn't get WISH. The Western Interstate Hydrogen Hub was not approved, and the state is trying to
Please
find
wrap
whatever
up.
water resources it can. So I urge you to continue to protect communities, families, and our future water resources. Thank you.
Thank you. Jessica Swan. Jessica Swan. If she rejoins us, I'll take her comment. Reyes DeVore.
Yes, I'm here.
Oh, hello. Do you swear or affirm to tell the truth?
Yes.
And would you spell your first and last name for the transcript?
Yes. REYESDEVORE.
Great. I will start your 3 minutes now.
Thank you. Good afternoon. My name is Reyes DeVore. I'm from the Pueblo of Jemez, and I am a mother first and foremost. I currently serve as the program director with Pueblo Action Alliance and had been with the organization since its beginning in 2016. When I think about water, I think about its sacredness, the way it is included in our cultural practices that my Hamish relatives and other Pueblo indigenous peoples have been living with for centuries now. Over the span of defense to protect it from settler colonialism, we continue to remain as the people who are fighting to protect it and keep the sustainability of our culture alive. Present day, we are still having to stand against the desecration and the contamination of land, air, and water that comes now in the form of extractive colonialism. I stand in opposition to the reuse of toxic oil and gas wastewater outside of the oil field. The strategic water supply plan that Governor Grisham announced is not a real solution, as it seeks to use contaminated water for agricultural, irrigation, potable water supplies, aquifer recharge, industrial processes, and environmental restoration, as stated in the proposed rule by the New Mexico Environmental Department. The new regulation being proposed comes as a result of surplus amounts of wastewater from oil and gas fracking, which is also a result of irresponsible practices from industry and the state. It is important to make it known that this plan will ask for $500 million over the next 2 years. What does that mean to us as community stakeholders? It means we're essentially needing to support the enormous wastewater problem, which has been created under the governor's leadership and the oil and gas industry. Additionally, to date, there are no known technologies that are capable of, quote unquote, treating the water to be completely free of toxic contaminants. This puts community health at further risk. We call upon this commission, New Mexico Governor Michelle Grisham, and the New Mexico Environmental Department to reconsider this plan that will impact community, our water, land, animal, and cultural lifeways. Thank you.
Thank you. Robert Bernstein. Robert Bernstein. Right. William Athis. William Athis. And if I'm mispronouncing your name, I apologize. Ooh, all right. Kathleen Burke. Kathleen Burke. Mary Whiteman. Patrick Hardemillo. Mark LeClaire. Oh, I see Mr. LeClaire there among the participants.
Yeah, can you hear me?
Yes, thank you very much. Do you swear or affirm to tell the truth?
I do. My name is
And
Mark.
if you would spell
Mark
your first and
LeClaire,
last name. Yes.
Yep, MarkLeClaire. And
Thank you.
thank you for taking my comments.
I'll start your 3 minutes now.
All right. Yeah, I'm a father of 3 here in Albuquerque, and I've farmed across central and northern New Mexico for the past 30 years. And I just want to say that I'm in support of strong rules to prohibit not only discharge, but any use of produced water outside of the oil fields. It's pretty clear, well, it's very clear to myself and to an overwhelming majority of the farmers that I'm in contact with and speak with that the waste from fracking is really should be reclassified as hazardous waste. People are opposed to any scheme that would lead to that water being used, treated, or untreated in agriculture. And I want to echo some of the other comments that this really feels like a movida to us when if the rule is not about using it for agriculture, then you should definitely remove that language from the bill. It just doesn't sit well with all the people that I talk to here in the valley, up north, the mayordomos, and up north. Everyone is very concerned about this, and we understand that not only is this water hazardous waste, but even I'm sure you've already heard about the health risks from all the other chemicals, but even the salinity of these waters is very concerning to us as farmers. And we understand that we're part of a large interconnected system, and the things that happen elsewhere upstream on other people's lands, those enter the air and water and affect all of us. So we're just adamantly opposed even to any experimentation with these hazardous wastes. And I'm also concerned with the vagueness of the language allowing for industrial use. As someone who's also been a carpenter and a construction worker my whole life, I'm very concerned for worker safety. And this may be beyond the purview of this board, but it seems to me that it's something that we should all be concerned about as far as having just a vague definition of industrial use and from what I understand, no permit required. I'm very concerned about worker safety. And the last comment I'd like to make, because I understand that there are representatives from the oil and gas industry sitting on this board, and it seems to me that if you all want to really enter into good faith conversation with the larger community about the problems that you're having with produced water, the first step you could take would be disclosure of your so-called proprietary fracking chemicals. That should really be the baseline that we begin these conversations from. So
That's your
thank you for
time,
hearing my
Mr.
comment.
Leclerc. Thank you. Kathy Sanchez. Miss Sanchez? Okay. Can you hear me? If she returns, I'll take her comment. Anna Rondon?
Yeah, hey, greetings.
Hello. Do you swear or affirm to tell the truth?
I do.
And would you spell your first and last name for the transcript?
ANNARONDON.
Thank you. I'll start your 3 minutes.
Thank you again. Yes, I would like to also greet the New Mexico Water Quality Control Commission. That's a really heavy title and a very strong responsibility to the people of New Mexico. I am born for the Towering House clan. That's where the viewpoint that I am presenting today to you all is from the clan I represent, which is originated over by Crown Point, New Mexico. We have a profound bond with our land, and by observations of your ancestors that came here, I want to evoke them, your indigenous roots from your European descent. There's been a disconnect of your original teachings. So today I come as a Kia'ani Towering House matriarch from our natural laws to present and stand with my voice for the man-made laws that do not protect our people no longer. Even the doctrine of discovery of Christianity, some of the oaths you take, it's on a Bible. That same thought of indigenous peoples and people of color and poor whites are less than human. Those days are gone. Today is a new day for our people. And for the people of New Mexico, we're tired of having mini Oppenheimers with this new hydrogen, new ways as experiments again and again. Just like New York, they tried to work with their oil and gas companies on their fracking, but they found that there is too much radioactivity. How much has the New Mexico Environment Department studied the tons and tons of radioactive materials from fracking? From the San
Ms.
Juan,
Rondon, please wrap up.
okay, from the San Juan Basin to the Permian Basin. Really need to protect these bowls of water, not for oil companies, not for outsiders. But with that, thank you, and may the holy people guide you. Thank you.
Thank you. Robert Bernstein?
Hey, thank you.
Yes.
I'm Robert. Oh,
Yeah.
do you want to swear
Okay.
me in, or should I spell my
Yes.
name?
First one, then the other. Do you swear
Okay.
or affirm to tell the truth?
Yes, I do.
Now I'd like you to spell your name.
Okay, Robert, R-O-B-E-R-T, Bernstein, B-E-R-N-S-T-E-I-N, M-D. M-D is medical doctor.
Thank you, Dr. Bernstein. I'll start your 3 minutes now.
Thank you very much. First of all, thank you for giving me time to speak. I'm a physician. I've been in Santa Fe for 40 years in private practice and also working at La Familia Medical Center. I'm concerned about everybody's health, and especially the health of my kids both kids they're adults now, they're born here, went to public school, went to UNM, and their children. I think the concern here is that wastewater from fracking contains numerous harmful substances, including sometimes radioactive material, uh, um, heavy metals such as arsenic and lead that can cause health harm, especially in young people, but in everybody, and also carcinogens such as benzene and toluene. And my concern is that the wastewater will contaminate our water supply and cause harm probably to us, but certainly to future generations. And again, I think our young people, children, babies are most vulnerable. So I think my opinion, and I should say I'm president of the New Mexico chapter of Physicians for Social Responsibility. So we represent a few hundred physicians in New Mexico and thousands nationwide. I think the rule should be amended or changed so that wastewater should not escape or be allowed beyond the boundary of the actual oil field. I'm not sure I'm being clear, but we want this wastewater to be segregated and completely separate from any possibility of contaminating our water supplies. So again, I thank you. I thank you for the time and appreciate the opportunity to speak.
Thank you, Doctor. Marta Flores?
I'm here.
Oh, great. Do you swear or affirm to tell the truth?
Yes.
Would you spell your first and last name?
Yes, my name is Mara Flores, Maraflores.
Thank you. I'll start your 3 minutes now.
Thank you. Good afternoon, Chair and Commissioners. My name is Mara Flores. I'm a recent immigrant and a member of EarthCare. I'm here to express my concern about the reuse of fracking produced water. As environmental science has found, the components of this water have high bioconcentration and high solubility. So it's not only about the water itself, but the infrastructure for transportation and the management of it that will be polluted. As you all know, everything is connected on this planet and everything is part of the big cycle of life. So it's important to take into account the possibility of exposure by humans and other beings, and the effects of on their health and metabolism. Regarding the use of this water in agricultural production, even when it could be in a controlled environment, there is the bioaccumulation of the pollutants into the plants. Then it's not clear what the disposal of or use of these plants and their products is going to be. Fracking produced water is hazardous waste that should be managed properly, and the industry that is generating it should be accountable for its safety management. Thank you for your time.
Thank you very much, Ms. Flores. Larry Sontag.
I'm here.
Hello. Do you swear or affirm to tell the truth?
I do.
If you would spell your first and last name.
LARRYSONNTAG.
Thank you. I'll start your 3 minutes.
Good afternoon, Commissioners. I'm Larry Sontag, a United States Air Force veteran, husband, father, grandfather, and 60-plus year resident of New Mexico. I'm part of a statewide grassroots organization called Better Together New Mexico. They encourage New Mexicans like me to get involved in important policy decisions like the one before you and to make our voice heard. So here we go. My understanding is that water reuse or recycling reclaims water from a variety of sources, then treats and reuses it for beneficial purposes, providing alternatives to existing water supplies, and can be used to enhance our water security, sustainability, and resilience. And hear this from the federal agency that has lots to say about water and our environment. That would be the U.S. Environmental Protection Agency. According to the EPA, sources of water for potential reuse can include municipal wastewater, industrial process and cooling water, stormwater, agricultural runoff and return flows, and produced water from natural resource extraction activities. Fact is, the EPA does not require or restrict any type of reuse. They encourage states to assert regulatory authority in allocating and developing water resources. So New Mexico, in adopting a proposed water reuse rule, is moving in the right direction. We live in an arid and desert climate, and each year we hear more and more about how crucial it is to conserve fresh water for generations to come. I have children still living in New Mexico, and I have grandchildren living in New Mexico, so this is important to me. We also live in a state that embraces new technology, especially when it provides jobs for working families in our state. Water technologies that exist now and will further evolve from adopting the proposed water reuse rule will require a skilled workforce capable of treating and monitoring the water. Environmental stewardship, to include conserving and reusing as much water as we can, is a win-win for current New Mexicans and for future generations. I encourage you to adopt the proposed water reuse rule that allows for the reuse and recycling of water produced from the extractive activities. Thank you.
Thank you, Mr. Sontag. Let me ask if there's anyone in the room who is present to offer comment at this session. I see your hand at the back. I see two hands at the back. All right. It might be okay. The department is vacating the witness table here just briefly. Hello, would you state and spell your name?
Yeah, my name is Crystal Curley, Krystal, and then Curley, Curley.
Do you swear or affirm to tell the truth?
Yes.
I'll start your 3 minutes now.
Good afternoon, Commissioners. My name is Crystal Curley. I'm the Executive Director of a nonprofit called Indigenous Lifeways. I am Dynamic Lanzar Kenyani.
She's giving you her affiliation.
Is my time going to be impacted with
No,
this?
I'll add second.
Okay. My clans are Kenyani Nishlan Kitlan Chitni Bashishchi, Nakaidine Dashiche, Aro Hanagatni Dashanale. And in English, that's Towering House, Red House, the one who walks around in the Mexican People Clan. And while I appreciate the efforts to address the water crisis in the state, I'm deeply concerned about the potential implications of the proposed regulation, particularly in the context of produced water reuse from oil and gas activities. The rulemaking misleads the public into thinking this type of water is reusable, but in fact, this is not water. This is a radioactive waste fluid that is a byproduct of the oil and gas industry. This is not solving our waste crisis. This is not solving our water crisis issue. This is a false solution to the toxic waste management that we are facing in New Mexico. This is merely a cover-up for the toxic waste mismanagement of the oil and gas industry. On average, New Mexico has 2 to 4 oil spills a day. We have no enforcement, no oversight, no monitoring or consequences for this industry. This toxic cocktail, so-called produced water, consists of 1,100 ingredients, and many of which are highly carcinogenic and radioactive. The potential reuse for industrial use will keep us dependent on the fossil fuel industry. There is an irreversible risk of exposure to radioactive contamination to soil and ecosystems, as well as potential adverse effects to human health. There is no appropriate treatment to reuse this fracked fluid. As a mother of 3 daughters, I'm standing here for their reproductive right to have healthy babies and to live in a clean environment with clean air and clean water, as my grandmother and my mother has done so for me. My county knows firsthand the impacts of exposure to radioactive contaminants. We cannot expose this radioactive fluid to our families, land, workers, and animals. I'm concerned that the proposed regulations may not adequately address the cumulative impacts of the reuse of radioactive byproducts from fracking. In a state facing challenges such as drought and depleting water and competing water demands, it is essential that we prioritize science-based knowledge that upholds Indigenous traditional ecologic knowledge as truth. As Indigenous people, we have the right to protect and defend our homelands and sacred sites. We know the devastation this exposure will cause to all Earth life, as we have been living with toxic exposure for over 140 years in McKinley County, from oil, coal, gas, fracking, and potentially hydrogen. We will not be subjected to the continuation of rulemaking without the Indigenous people's voice. We are not your sacrifice zone. We are not your toxic waste dump. Thank you for considering my comments on this important issue. I trust that the Water Quality Control Commission will carefully evaluate all feedback received and make a decision that prioritizes the long-term sustainability and well-being of all New Mexican water resources, communities, and hold the fossil fuel industry accountable.
Thank you, Ms. Curley. If you would state and spell your name.
Good afternoon, commissioners. Ooh, that's loud. My name is Christina M. Castro, PhD. Christina, Christina, middle initial M, last name Castro, Castro.
Do you swear or affirm to tell the truth?
Yes.
I'll start your time.
Thank you. Good afternoon, commissioners. I would like to echo similar sentiments to what Crystal Curley just expressed. I am a Pueblo woman, matriarch, community organizer, scholar, and I come here in defense of my communities. I'm Taos Pueblo and Jemez Pueblo. I am a farmer. I'm very concerned about these industries that are an outcropping of nuclear colonialist interests. Our people have been subject to these industries for, like Crystal said, over 100 years. I really am fatigued in this, having to do this kind of advocacy as an Indigenous person in defense for our humanity, our lands, our lifeways. It's really painful, honestly, to have to keep doing this work. Our people seem to be sacrificial to these capitalist interests. Our land, our culture is embedded in these lands. Our ceremonial cycles are embedded in these lands. It really baffles me that we have to sit here and have these same conversations with you all. This is like so elementary. We all live on this land. We all are New Mexicans here, either by choice, by indigeneity. Y'all are here. And we have to keep having these conversations with you about things that affect all of us, not just Indigenous people. We live under Los Alamos. I'm Jemez Pueblo. Our family and our lands have experienced the off runs of all that toxic byproducts from that industry. Now to think about the nuclear corridor in the southeastern part of the state, thinking about our water being used to frack and then repurposed and sold in industries where, again, our people are going to be most impacted. I don't understand why we have to keep having these conversations. It pains me. It pains our communities. So I would ask you to look into your hearts and ask yourself, what part of the responsibility do you have to protect these lands that we all love? I mean, our whole state thrives off of tourism. We can accept that. Indigenous people are a huge driving force in tourism in this state. You see all these advertisements for New Mexico True, rafting, hiking, backpacking, you name it. People are coming here from all over the world. But yet we have to sit here and advocate for the health of our lands and communities. It's so tiring. It's so tired. It's so like old. It's so antiquated.
Would you wrap up?
Yes, I will wrap up. Thank you for this time. We all are responsible for this. And what you all do and how you vote has a direct impact on only not Indigenous people, but all of you and your progeny and your futures. So thank you.
Thank you. Thank you, Ms. Castro. We have time for another comment. Kathy Sanchez apparently may be able to unmute herself at this point. Ms. Sanchez?
Can you hear me?
Yes, I can.
Oh, good. All right. Swear me in.
Swear? Oh, yes. Do you swear or affirm to tell the truth?
Yes, I do.
And if you would spell your names for the transcript.
Kathy, Kathy, Wempovi, WANPO, Victor I, VI, Wempovi, Sanchez, Sanchez.
Thank you. I'll start your time.
Thank you. Sengitamo umbiagindi. Na no hot opportunity he came out na mit I know the point ni the kagen na mit hill. That was just in Tewa so that I could center my spirit with my ancestors as this conversation is held in our immortal lands of ancestors being here and the dead and the dying that are in the ground, the fossil fuels, the decaying animal lives and plants that were here before are being dug up, taken out of their graves before their due time. And so I would like to share a story in a story format, which comes to mind because of what I'm hearing so far. So the story I'd like to share is about two humanoid creatures. And this is a story that an wise elder was telling his grandson about a battle that goes on within people. And I hear this today. He said, "My son, the battle is between two humanoid creatures. They're inside all of us, all those sitting here on the panel, on the commission, on us participants here. One is evil, immorally unholy. It is about power and control over others. It's about money and greed, anger, envy, jealousy, hatred, saving face, arrogance, resentment, lies, false documentations, hyped up, superiority assumed because we can flaunt the money, and very ego Eurocentric orientated. Now the other is good, says the grandfather. It is joy, peace, love, hope, serenity, humanity, kindness, empathy, generosity, truth, compassion. Do not harm, do no harm, very precautionary, principled, orientated. Now the grandson thought about this for a minute and then asked, but which humanoid creature is going to win? The wise old elder simply replied, the one you feed. You must eat yourself from inside out. If you are without consciousness, without a heart, are we fully in a collective infinity of relationality of the loving cosmic heart energy within premortal time of our multiverse? I don't know if that story hits home, but I think it should, in that what we're talking about now is we wake up your consciousness. What you're talking about is lip service to an industry that is dealing with terminology that can disguise what it appears to be as produced water, radioactive toxic waste that is a byproduct of wanting just oil and gas, and when what comes up is very not sacred water anymore, and yet you buy our sacred water from people that want to sell it in order to make money, so that there's a win-win for.
Would you wrap up, please?
Okay, yeah, just wanted to raise the consciousness of people, and that I am against this rule to reject, reuse this crazy, dirty water. Not even water. It's not even water anymore. It's waste product. Thank you.
Thank you. We've come to the end of the public comment, the 1 o'clock public comment session. There are two more public comment sessions at 9 o'clock tomorrow morning and 1 o'clock tomorrow afternoon. There are likely to be additional public comment sessions, but those are the two that we know about right now. Ms. Taylor, I see you on your feet. You have to come to a microphone.
Yes, ma'am. I think if you would agree, this could be a good time to talk about scheduling, perhaps? Or what were you thinking?
What I was hoping we could finish cross-examination. Mr. Chair, when is the best time to discuss scheduling?
I would suggest we wait to discuss scheduling until we know that Mr. Hightower is online. And my sense was he was going to log in this afternoon when he got to his destination.
Right. And we haven't seen him yet. We haven't seen him yet.
Very well, thank you.
Yeah, we haven't forgotten that we need to talk about scheduling. Thank you. All right, we're going to resume questioning of the department panel. When we broke for lunch, Mr. Davis was in the middle of his questions. Mr. Davis, if you have additional questions, go ahead.
Thank you, Madam Hearing Officer. Given my performance with copying a two-sided document one-sided yesterday, I have decided to try a different strategy. So, Ms. Jones, if you don't mind putting up Wild Earth Guardians Exhibit 15 on the screen, and then I'll ask the panel and the commissioners to take a look at NMED Exhibit 128 on your computers.
Excuse me, it's just the one document?
Yes.
Okay.
Thank you so much, Ms. Jones. The exhibit that you see on the big screen here, Wild Earth Guardians 15, is a copy of a provision in the New Mexico Administrative Code, 19.15.16.19. And I'm not going to read subsection B for you, but Ms. Murphy, I believe you, in your direct testimony, testified about the Frac Focus database. Is that fair?
That's fair.
And is it also fair to say that subsection B of the administrative code provision that's up on the big screen requires disclosure in the Frac Focus chemical database for hydraulically fractured wells?
Yes.
And I am going to read subsection 2 there under subsection B, which states that the division, this is the Oil Conservation Division, the division does not require the reporting or disclosure of proprietary, trade secret, or confidential business information. Did I read that correctly?
You did.
If I could turn your attention now to NMED Exhibit 128, can you please describe what this exhibit is?
So part of it is the first page was a snip of the web page, the front of the web page. And then the second was, I think the next page was a snip of what the southeast part of the state looks like. There's a map and it shows a number of wells, actually 14,000 wells. And then below that, it starts to show, there's a little write-up about what Frac Focus is. And then on starting on page 5, it's individual wells. And I just clicked on a number of individual wells to show how they come up. And then what they do is they list trade secrets below.
Okay. So I'd like to start with what I believe there's a series of different wells that you pulled information from. And I believe the first one was a Chevron USA well in Eddy County.
Yes.
And if we look at the chart for this well, there are numerous columns, but there's a column for ingredients. And beside that, there's a column for chemical abstract service number. Could you tell us what a chemical abstract service number is?
I believe it's similar, or it's a an MSDS.
Yeah, I think it lacks SSN social security number. So it's referred to individual person. Each CAS number refers to each chemicals.
Is it fair to say that the chemical abstract service number allows you to positively identify a chemical compound?
Could you please repeat your question?
Is it fair to say that the chemical abstract service number is a number that identifies a chemical compound? It's assigned to a specific chemical compound?
I think so.
Ms. Murphy, if I could turn back to you. As we look through the columns for ingredients and chemical abstract service number, and now I've just turned to what's labeled as Bates 003465, but that's just the next page under the Chevron USA well. Are you with me?
Yes.
There are numerous entries into the chemical abstract service number column that do not contain a number. Is that right?
That's right.
Instead of a number, it says proprietary.
It does.
So there's no way for you to use the Frac Focus database to identify what those chemicals are.
No.
If we turn to the next well entry, this is a Cimarex Energy Company well in Lee County. Is that correct?
That's correct.
And again, if we look at the column for chemical abstract service numbers, there are multiple entries that say proprietary.
There are.
For the sake of time, I'm not going to go through each one of these, but is it fair to say that for each one of these wells that you pulled information from and entered into this NMED Exhibit 128, that there are undisclosed chemicals?
There are.
Is it fair to say that these chemicals are unknown to the department?
They're unknown to me, for sure.
Is it fair to say they're unknown to you because they're undisclosed?
Yes.
Do you know if, let me start over. Yesterday, I spoke with Mr. Hightower about a list of pilot projects that currently exist in the state. Do you recall that conversation?
Yes.
Do you know if there were undisclosed chemicals in the source produced water used in any of those projects?
I don't know.
I believe you also testified earlier in the week that thorough characterization is important for source produced water.
True.
It's also important for characterization along what has been referred to as the treatment train.
True.
If there are undisclosed chemicals in the source produced water for any of these pilot projects, is it possible to attain thorough characterization?
The best available technology that we have is from the consortium, and that's their under their guidance and sampling document, and that is the NPDES plus list, whole effluent toxicology, and non-targeted analysis.
Using non-targeted analysis, is it possible to quantify a chemical?
Quantify mean the name?
Quantify meaning the amount.
I don't know about that.
Using non-targeted analysis, is it possible with 100% accuracy to identify all unknown chemicals in a given sample?
Non-targeted analysis is helpful to identify the unknown chemicals. But we are not. It's a method to identify the untargeted analysis. And it's a method to identify the unknown chemicals, but it's not the only method.
Is it possible to identify the unknown chemicals with 100% accuracy using non-targeted methods?
To my knowledge, no.
Thank you, Dr. Hu. Ms. Murphy, I have just a few more questions for you.
Okay.
Are you familiar with NMED Exhibit 138? And this is the list of pilot projects I discussed with Mr. Hightower yesterday.
I am.
Ms. Jones, I'm going to have to ask you to put one more up on the screen for me. It's Wild Earth Guardians Exhibit 16, which I uploaded this morning, and I emailed to you as well. Thank you. Ms. Murphy, do you recognize the exhibit that's marked as Wild Earth Guardian 16 on the screen above you?
Yes.
I pulled this from the Produce Water Research Consortium's webpage this morning. My understanding, and it was labeled as an October 2023 update. Are you familiar with that? Is that accurate that it's an October 2023 update?
It says October 23 at the top.
My first question is whether this is the most recent list of pilot projects or NMED Exhibit 138 is the most recent, if either is.
There's a more recent consortium document. We've been emailed it, and I know that because it's in May. And my Excel table, I updated when I added some information about Devon.
So Wild Earth Guardians Exhibit 16 is not the most recent list, to your knowledge.
No, there's a May 2024.
Do you have data from any completed consortium projects? You have completed data from any completed projects?
So can we look at one table at a time?
Sure. And I'm not specifically talking about either of these tables. I really just wanted to know if there was a most current version and which it was. My next question is whether for any of the existing pilot projects that you are aware of, do you have completed data?
So in my table, there's 7 active projects. In my list, there's Canales, that's in the San Juan Basin. There's New Mexico Tech, Tesco, and Hillcorp, that's also in the San Juan Basin. And the rest are in the Permian Basin, Sun Vapor, Infinity Water Solutions, Tascosa, and Devon. Oh, and one more, Solmem.
Do you have data from any of these projects?
I don't believe any of them have completed. I'm not, I think Solmem is in Bergendorf. And I believe that the Canales project is in the San Juan Basin, but I don't know that any of the other projects have started.
I'm not sure if you stated this Monday or someone else on the panel did, but is it true that the department's not aware of all the pilot projects that exist currently?
So that would have been in my oral. And that was where I said, I was asked, currently does NMED know where all the produced water demonstration projects are occurring in the state? And I answered, it is unclear. There may be projects occurring in the state that have not submitted an NOI to NMED, and thus NMED has not had the opportunity to determine if they are non-discharging.
Is NMED a partner in the consortium?
We participate in the consortium.
If I could take a swing on that one. I believe it's been mostly described that we're the customer of the consortium, that we are not a member. We have a memorandum of agreement or understanding, not agreement. Agreements have money, understandings don't. And that we are there and are participating in it in order to get the information necessary to promulgate regulations.
Under that agreement, or you may have said an MOU, is part of that agreement about how data will be shared and updates will be given about these projects?
So there is, in the 2022 MOU, there is an information sharing plan, and that is on page 11 of NMOGA Exhibit 029.
Does the consortium give the department regular status reports on these projects?
I can answer that one. We attend the consortium meetings. However, we have not received an update in writing, at least since April of 2023 when I've come on. 2023. And Mr. Herman has been here longer, so he may be able to.
Same answer. Since 2019. 2020. Sorry, 2020 is the correct year.
Has the department made any determinations about these pilot projects based on the data that you have received so far?
So these projects are in their preliminary stages. And the table that I make is based on the NOI. And so in my table, I list pertinent data. What basin it's in, when it's estimated to start, who's the contact person. The estimates of the volumes that they're going to use in the project. The treatment methodology, is it part or the entire treatment train? Some of the operational characteristics, the website if a company has it. How long a project is proposed to last. The recovery rate, if they have it in there, estimated volumes that they're going to use, and it's kind of a treatment description. So that's what I put in my table.
Is it fair to say that the department does not have enough data from the consortium to make any determinations related to the pilot projects that are in existence?
When you compare the tables, this is why I made my table. This is not adequate. And so that's why I crafted this table and put it online.
And just to be clear, when you say this is not adequate, you're referring to the table that's marked as Wild Earth Guardians Exhibit 16?
Yes, the table from the consortium.
And I believe you have already said that you're familiar with Wild Earth Guardians Exhibit 16, correct?
Yes.
Is this a true and accurate copy of the table from the consortium's website?
Yes, it's the standard format.
Madam Hearing Officer, I would move Wild Earth Guardians Exhibit 16 into evidence.
I'll pause in the event there are objections. It's admitted.
Ms. Fulham, I'd like to turn to you, please.
Yes.
I believe you stated previously in the week that the dose makes the poison.
I did.
And in your rebuttal testimony, I believe you also stated that, quote, without source water characterization on what contaminants are present, it is premature to determine what treatment options would be viable or what effluent quality could be attained.
That sounds accurate.
Is part of source water characterization the identification of the chemicals in that source water?
It's where we start.
And part of source water characterization would then be to quantify those identified chemicals?
Correct.
If you're unable to identify the chemicals in a sample, whether it's treated produced water, raw produced water, reuse water, etc., waste stream, if you're unable to identify the constituents in that sample, can you determine toxicity?
There are methods to determine whether there's a toxic effect without knowing the actual concentrations.
Are you referring to whole effluent toxicity testing?
That is one of the methods that could be used.
And that's also commonly referred to as wet testing.
Correct.
I'm going to refer to it as wet testing for the rest of our time together because I have a hard time stringing those other three words together, apparently.
Fair.
Ms. Lucas Kamat, I believe you do testify about wet testing.
Yes, I do.
And this is a non-targeted testing method that's purpose is to determine whether a given sample is toxic, correct?
Correct.
And whether it is toxic to whatever specimens it's subjected to. Is that fair to say?
That is fair to say. Wet testing uses specific, I've got specimens stuck in my brain now, so I can't think of the right word. I have specimens stuck in my brain. It should be species. Use specific species, either marine or freshwater, and the species are selected based on what has the toxic effect.
Is it fair to say that the species that are used in wet testing are not the same species that effluent may encounter in the natural environment?
Correct.
Is it fair to say that the species used in wet testing are not the same species that the testing intends to protect?
Can you rephrase the question, please? Or
Sure.
restate it?
My understanding of wet testing is that there are certain species that are subjected to a given sample, and that those species are not the same species that the wet testing intends to protect. In other words, wet testing could be used in an attempt to determine whether a sample may be toxic to humans. However, humans are not used in wet testing.
Correct.
Wet testing takes place in a controlled laboratory environment. Is that correct?
Correct.
So the lab environment does not necessarily represent a real world environment.
The laboratory environment is a controlled environment. So in that sense, it's not the real world, but it is, yeah.
So if we assume real world means outside of the laboratory, is it fair to say that real world environments may contain cumulative stressors?
Correct.
And that those cumulative stressors are not necessarily replicated in lab testing?
Correct.
Is it also fair to say that real world environments include additional exposures that would not be present in the lab environment?
Correct.
Is it fair to say that wet testing results are variable?
Correct.
You state in your rebuttal testimony that the Clean Water Act's prohibition on the discharge of toxic pollutants in toxic amounts for acute versus chronic or reproductive exposures. And this is in the context of wet testing, and I just want to ask you a few questions about that. Wet testing results give researchers data on acute exposures. Is that right?
Correct.
And so performing a wet test for a given sample, whether it's produced water, treated produced water, waste stream, any part of this process, that wet test does not tell the researcher anything about chronic exposure.
Wet tests are conducted using different dilutions, and they're conducted, there's like an acute series you'd run and a chronic series you run. So if you do a complete wet test, you can get both.
Would a wet test provide data related to exposure, repeated exposure to one of these samples over a series of years?
To my knowledge, no.
Would wet testing account for exposure to the accumulation of toxins over time from downstream sources?
Can you rephrase the question? Because I don't understand
Sure.
how you could have exposure from a downstream source.
Sure. If you, effluent over time can deposit toxins downstream. Is that fair to say?
Downstream of the point of discharge?
Yes. And as those accumulate, cause the dose makes the poison, would the accumulation be, is it fair to say that would be more toxic? In other words, it would concentrate toxins?
Toxins can accumulate downstream of a discharge, yes.
Does a wet test give us any data on exposure to the accumulated toxins?
No.
Mr. Herman, if I could turn to you. You testify in rebuttal, dates 4619, lines 16 through 21. Quote, the only references made to disposal of waste products in the proposed regulations clearly state that all waste products that result from industrial and demonstration projects must be disposed of appropriately and in accordance with all regulations governing those disposal activities, which could include combining the treated produced water and the waste streams back into their original state for transfer and disposal back in the oil and gas disposal facilities that are regulated by MNERD. Is that an accurate statement of your testimony?
We haven't quite pulled it up, but if you're saying that you're quoting me, I'm going to believe you and say yes.
In your testimony that I just read, when you say waste products, would that be the components of a demonstration or industrial project that are outlined in the proposed rule at subsection 400B8I?
Could you give me an example?
Sure.
Of what you're talking about?
Sure. So let's just start with the proposed rule. In the proposed rule at subsection 400B8I, that's the section that states that components of a demonstration or industrial project must be disposed of. I think the word is actually adhere to state, local, and federal law. Is that your understanding of that section?
Yes.
So my question is really, what are the components? So would the components of the project include the waste stream from the treatment train?
Yes.
Would the components also include the treated produced water?
Unless consumed in some way, shape, or form by the project itself, yes.
So if those components, let me rephrase, if treated produced water is one of those components that must be disposed of in adherence with state, local, or federal law, is it also true that the proposed rule dictates that treated produced water must go back to the oil field for disposal pursuant to OCD facilities?
There's examples that would the regulations identify hydrogen production. That would be separating out the hydrogen atoms from the treated produced water. That those hydrogen atoms would not need to be returned to the oil and gas field in those situations. There's a proposed pilot project, which you've mentioned previously, that is testing growing seedlings, pine seedlings. The pine seedlings themselves that have taken up the treated produced water at this time would not be allowed to be dispersed. It would have to be disposed of in that manner, as described in the regulations.
Under the proposed rule, is it true that treated produced water must always be disposed of on the oil field via OCD permitted disposal methods?
I'm going to take my time and think about the answer to this one. I cannot think of an example where that would not be true.
I'd like to ask you as well about reuse water. The proposed regulation defines reuse water as treated produced water that's been treated to an appropriate level for a given end use. Is that a fair?
I think that misstates the definition of reuse water.
Let me pull it up.
I have it up, but I can read it if you'd like.
Sure. Thank you.
Reuse water means a treated wastewater originating from domestic, industrial, or produced waters sources that has undergone a level of treatment appropriate for an application such as agriculture, irrigation, potable water supplies, aquifer recharge, industrial processes, or environmental restoration. Would you like me to continue?
Is it fair to say then reuse water is something different from treated produced water under the proposed rule?
I answer that for you?
Sure.
I would say yes.
Sure. Thank you. So I had the same question about reuse water that I did about treated produced water, which is reuse water a quote component? Could it be? Let me rephrase. Could reuse water be a component of a demonstration or industrial project?
I don't believe so. Would you like me to elaborate? Based on your expression.
Sure.
This is the process, the thought process. So reuse water says that it's treated wastewater originating from domestic, industrial, or produced water source that has undergone a level of treatment appropriate for an application. An application is a discharge. The application is explicitly prohibited under the proposed rules. Therefore, treated produced water is not being used for an application. It is only describing that the water from the produced water source has undergone a treatment process, and treatment is defined Thus the need to have some layering of those definitions, because this is not a produced water rule, this is a reuse rule. And so reuse water applies to all water sources that would potentially be used for an application. Just produced water is not one.
Reuse water could come from a treated produced water source.
This point, the way the regulation is written, no, because there are no authorized applications for the use of treated produced water. And a reuse water explicitly states that it's appropriate for an application.
Mr. Herman, going back to your rebuttal testimony, I believe you said that the department has made every effort to obtain research data, produced water samples, and other information in order to promulgate such standards, but has received almost nothing from industry proponents who are pushing for the discharge of treated produced water. Does that sound like an accurate statement of your testimony?
Yes.
My question is whether in that statement you would include the consortium.
Yes.
Dr. Hu, I'd like to briefly turn to you. You testify in your direct at a Bates 000133 through 000144 about different methods and stages of the treatment process for produced water. Is that correct?
Which page?
Beginning at Bates number 000133.
The exhibits we have don't necessarily have the Bates number, so if you give the page number or the PDF
Sure.
number, that is helpful.
Maybe this is a quicker way to get there. Dr. Hu, do you testify in your direct testimony about different treatment methods for produced water?
Yes.
Do you testify in your direct testimony about different stages in the treatment process for produced water?
Yes.
During the treatment process for produced water, does the chemical composition change from the original source water composition?
Can you repeat your question?
Sure. During the treatment process for produced water, does the chemical composition change as compared to the original source water?
It may be.
During the treatment process, are new chemicals introduced to the source water?
I think so.
When you say you think so, does it depend on the type of treatment?
Yes.
Are there types of treatment that introduce new chemicals into the source produced water?
For some chemical methods, you have to add chemicals into the produced water. Then you introduce the chemicals in the produced water.
Does the addition of those chemicals change the chemical makeup of the source produced water?
Depending on the treatment technologies.
Mr. Davis, would you identify a good stopping point for a break, please?
Sure. Just a couple more questions. I think I can be finished. Dr. Hu, I'm sorry, can you please restate your last answer?
Yeah, I said it depends on the treatment technologies.
But there are treatment technologies that would change the chemical composition of the source produced water.
For some chemical treatment technologies, it will generate some byproducts during the treatment.
Would that change the chemical composition of the water being treated?
It may be.
Okay. I have nothing further. Thank you all very much.
Thank you, Mr. Davis. Let's take 10 minutes. We are back after a short break. When we broke, I believe Mr. Davis had completed his questioning of the department panel. We move then to Mr. Dodd, I believe. Thank you. And we'll continue with the questioning.
Thank you, Madam Hearing Officer. I could have just 1 second. Ms. Fulham, I'd like to talk with you about water. In your direct testimony, you write about how water is not made. It's repurposed over and over again. And that's the hydrological cycle or hydrologic cycle.
That's correct.
And water generally isn't created or destroyed. It just moves around and changes form, correct?
Correct.
I'm sorry, hold on, Mr. Dodd. Ms. Taylor? Right. We are in contact with him, but thank you. We're going to finish the department. It's all right. Go ahead, Mr. Dodd.
Thank you. So I have a mug of coffee right here. This mug of coffee was made by taking some beans, grinding them up, and pouring boiling water over them. And doing that, we end up with coffee, right?
Correct.
And I want to ask you a question that can get a little bit philosophical. You would agree that coffee is not water, correct?
Can I ask the line of questioning as it pertains to my testimony or the role?
Yeah, I was gonna ask that same question.
I'm trying to give an example that I think is going to be as illustrative.
Right. But even as I'm sitting here, Mr. Dodd, I'm thinking, well, coffee is made with water. Is that where you're going? It's there. So
I'm trying to make a distinction. That's right.
Okay, there are too many possibilities. So if you could either give her a clue as to what path you're going or ask her to confirm something that you believe.
Okay. Coffee has water in it, correct?
Correct.
But coffee is not water. It's not just water, right?
It is not just water.
There are lots of other things in it.
Correct.
For example, it has caffeine in it.
It may.
And generally, you wouldn't give coffee to a child because it might be bad for them.
I really don't believe that this is within my direct testimony.
Mr. Dodd, she's not been given any testimony about childhood development or anything like that.
Okay.
Let's just bring it back.
Okay. So going to the purification process and trying to remove things to remain or to end up with just water. If we were going to process coffee, we would want to test the coffee to figure out what's in it first, correct?
Yes.
And then we would come up with a list of different ways of filtering it and treating it to try and remove all of the chemicals, right?
Yes.
And after we run it through all of those different treatment processes, we would test it again and make sure that we were successful, that all of the identified chemicals had been removed.
Yes.
Now, you would agree that depending upon the liquid that you are treating and trying to purify into water, there may be different processes for doing purification.
Yes. Again, I don't believe that I talked about treatment in my testimony.
Okay.
I mean, if you can point it to me, I'll be glad to talk about it.
I'm going to move on at this point, okay? I just wanted to sort of set the stage for talking about produced water.
Right.
Okay.
Right.
So you would agree that what the oil and gas industry has termed produced water isn't just water, correct?
Correct.
It has water in it, but it has a bunch of other stuff in it as well.
I believe Dr. Who testified to that.
Are you aware of what percentage of the produced water coming out of the Permian Basin is actually water?
I don't believe I testified to that.
Okay. You've heard testimony here during these proceedings that up to 20% of the water is actually just total dissolved solids, correct?
I actually can't quote what I've heard over the past 4 days.
Okay.
At this point, I'm
it's
sorry.
tough. Have any of the panel, are you any of you aware of that? That 200,000 milligrams per liter can be total dissolved solids in Permian Basin water.
Do you need us to find the reference for that for you?
So Mr. Dodd, I believe I remember that testimony, and so I think that is an appropriate assumption to ask them to make and then ask your real question.
Okay. So 200,000 milligrams per liter is 200 grams, correct?
Okay.
Is that correct?
I'm not in a place to do the math right now.
You can ask them to assume that. That's what you're representing.
I mean, Madam Hearing Officer, these are the members of the New Mexico Environmental Department that are here testifying about the produced water. I'm just asking a simple scientific question.
Can I make a correction?
Yeah.
We are actually testifying to proposed language in a reuse regulation. And my testimony does speak to that. And I'd be glad to answer some questions for that.
Okay, and Mr. Dodd, you're exploring someone else's testimony with them, and I'm not sure how helpful it is to ask them to go through a mathematical calculation related to someone else's testimony. So again, to the extent we heard that testimony yesterday or the day before, you can certainly ask them about it. It's just not their testimony.
Okay. Mr. Herman, it looks like you might have something to say about.
I would attest to 200,000 parts per million is 20% of 1 million. And that if you were to have 1 million grains of salt, or I'm sorry, 1 million grains of capacity, that 200,000 grains of salt in that full capacity would be 20%.
Okay. Thank you. So the reality is that produced water is a toxic waste that's created during the oil extraction process, correct? Or extracted during the oil extraction process.
Could you define toxic?
It contains contaminants.
It does contain contaminants.
And this toxic waste contains complex known and unknown constituents.
I believe that's in one of our testimony, yes.
And there are significant hurdles to treating and purifying the toxic waste to remove all of these contaminants.
I believe Dr. Hu testified to that.
And since we don't know exactly what the constituents are of the produced water, that makes it impossible to ensure that all of the toxic impurities have been removed.
I believe that adds a challenge to it.
Because if you don't know what you're looking for, you can't know what tests you need to run.
It does add to the complexity of it, yes.
You state in your direct testimony, and this is at NMED Exhibit 2 at page 25, lines 5 through 7, quote, if the contaminants in the source water remain uncharacterized or unknown, there is no ability to appropriately evaluate what type or level of treatment is necessary to yield the water quality that is protective for a particular application. Did I read that correctly?
You did.
Accordingly, you also state in your direct testimony, quote, research to characterize the water is needed to determine if there are viable and effective treatment methodologies for protective reuse applications outside the oil and gas sector, and what constituents are concentrated in the secondary waste streams. Correct?
Do you have?
Sorry, I'll give you the site.
Thank you.
That's at page 6, lines 12 through 14.
That's why I couldn't find it. Lines 5 through 14?
12 through 14.
12 through 14? Yes.
And then looking at page 27, lines 18 to 22. And I'll give you just a moment to pull that up.
Thanks. Okay.
Quote, because produced water has variable quality and constituents, an unknowable number of which are unknown, as described in Kathleen Murphy's and Dr. Lei Hu's written direct technical testimony. Applicable treatment methods are also variable with unknown assurances for water quality. Close quote. Did I read that correctly?
Yes.
And so ultimately, NMED agrees that the viability of this toxic waste as a wastewater reuse source still remains to be determined, correct?
I would caveat that and state that I have not declared it to be a toxic waste. That's a very definitive term that I couldn't assert.
Let me restate the question
Okay.
then. You agree that the viability of produced water as a wastewater reuse source still remains to be determined.
I can agree to that.
You would agree that NMED does not have the data necessary to evaluate the characterization of raw produced water, appropriate treatment methodologies, potential effluent quality, safe handling practices, or safe disposal practices of the waste streams, correct?
For the first three, for sure. I don't know that I will attest to the last two.
If you could you go to page 43 of your testimony, your direct testimony, at lines 18 to 20?
Yes. Yeah, I did say that.
Okay, thank you very much. And so you would agree that additional research is necessary to determine the appropriate standards for discharge, handling, transport, storage, recycling, and treatment of produced water.
Of the disposition of the treated produced water, yes.
Okay. And that's because at this point, we don't have credible scientific data to adequately regulate those uses of produced water.
In part, yes. There's more to that.
There's other reasons, but that's one of the reasons as well.
Yes.
And because of the lack of scientific data, we don't know the degree of risk that produced water, whether treated or untreated, poses to health, welfare, and the environment.
That would be correct.
So let's talk about the lack of data. NMED is frustrated by the lack of data on produced water, correct?
I don't know that an agency has emotion, so I don't know about frustrated.
The staff members of NMED, some of whom might be present here today and testifying, have been frustrated by the lack of data on produced water, correct?
Again, I don't know that our personal opinions are of any consequence. We have not received the data in order to make that determination. I will give you that.
And you would agree that without data, it makes it hard for you to do your job to regulate produced water, correct?
At this point, there are no discharges, so that does not make that difficult.
Okay. NMED is frustrated with Mike Hightower's leadership and lack of organization at the consortium, correct?
Is that stated somewhere?
I'm asking you if that's correct or not.
I'm asking if that's been stated somewhere.
That's not the question that I'm asking.
There's no frustration that I can attest to.
Okay. The consortium has been unable to bring you credible scientific data about produced water treatment and reuse.
That's not entirely correct. The consortium and NMSU have produced publications regarding produced water.
Some.
Yes.
You would agree that it's inadequate to date, correct?
Inadequate for what?
For you to be able to develop comprehensive regulations regarding produced water.
Standards, not necessarily regulations.
Okay. The reason that the consortium exists is to bring you data regarding produced water, correct?
That's my understanding of the MOU, yes.
Now, looking to your direct testimony at page 13, lines 20 to 23, you testified on direct, quote, data is critical for determining source characterization, appropriate and viable treatment methodologies, management of secondary waste streams, and finding viable applications for the use of or disposal of treated produced water, correct?
I stated that, yes.
And there just isn't enough evidence and scientific data at this point to be able to do those things, correct?
Correct.
Now, yesterday, Mr. Hightower testified. And he stated that NMED had access to information in December 2023 from a project that was not listed on NMED Exhibit 138. That is not true, is it?
Let me pull up Exhibit 138.
Sure.
Oh, the list of produced water demonstration projects?
Correct.
Can you repeat the question again?
Absolutely. Yesterday, Mr. Hightower testified that NMED had access to information in December of 2023 from a project that was not listed on NMED Exhibit 138. That testimony was not true, correct?
I believe what it's weird because he's not here. He was referring to a presentation that was given that listed results at a meeting that Susan was at. Yes, Lucas, come on.
Yes, the annual Produced Water Research Consortium had a presentation, multiple presentations that included data, but that was not submitted to NMED.
Okay. Now, data that is coming from, or information that is based on data that has not been presented to NMED is not particularly valuable for NMED in determining how to treat produced water or regulate produced water, because NMED doesn't have the ability to check the data and make sure that it's reliable, correct? And NMED Exhibit 138 is the list of all of the pilot projects that they're supposed to be data reporting for, correct?
This is a list provided by or culminated by Ms. Murphy, and it only has the demonstration projects that are within New Mexico.
Okay.
I'm sorry, and their presence on the list does not automatically mean that we would have data or that data has been submitted.
And that's because many or most of those projects, there's been no data reported, correct?
Correct.
Now that spreadsheet that's in evidence is NMED Exhibit 138. As it's presented by NMED, it's in a PDF format that I find a little bit hard to navigate. And so NEE has uploaded NMED's Excel spreadsheet in the Excel format as NEE Exhibit number 17. And that is in the Dropbox folder. I don't know if do you guys have access to the Dropbox folder from there?
I do not.
I will fetch you Ms. Nanasi's laptop so that you can look at the Excel spreadsheet, just because it's easier to navigate. Okay?
Thank you.
Can I have just a moment? This folder?
Yes,
Ms. Nanasi just emailed it to you. Can you pull it up there, actually?
I actually
don't have
cannot
it.
access anything
figured
while
that
we're
might
testifying. We do have a hard copy here that I can refer to.
Oh, there's Ms. Nanasi now. Oh.
May I refer to the hard copy?
You could, but I'm telling you now, it'll be complicated. Mr. Down is going to provide you with a laptop with it. And Ms. Jones, if you could possibly pull it up as well. Ms. Nanasi sent it to you. It's NEE Exhibit 17. That's correct. So as Ms. Jones is pulling that up, I'll ask a few questions. Now, Mr. Hightower testified that for the first 7 projects on here, the ones that are highlighted in yellow, that NMED hasn't been provided any data because these projects are just getting off of the ground, correct?
Believe that Mr. Hightower gave a reason for each and every one of these, and some of which have not begun.
Okay. But he did assure us that the consortium would upload all of that data when they got it, correct?
I believe he did make a statement to that effect.
So I want to look at the first project listed on this exhibit. That's the Canales project, right?
Yes.
And could you scroll over to column Y for me? And if you could please read the information for the Canales project in column Y. That's the one that's labeled lab analysis.
It says completed lab analysis through New Mexico PWRC, meaning Produced Water Research Consortium, risk and toxicology protocol. Lab analysis has been completed and should be available on the New Mexico Water Star data portal.
NMED hasn't received that data, has it?
No.
Now, could you go over to column X for the same project, the operations and time frame for pilot column?
I'm there.
And Ms. Jones, is there any way that you could zoom in a little bit on that? I'm sorry, Ms. Jones. A little bit, I think. There we go. Yes, and if we could go over to column X, please, the operations and time frame. Just 1 second, please. But here for the Canales project, there is no note that it's estimated. It simply states, quote, 25% recovery rate, close quote.
You know, that's true. The previous column they have run 1,000 gallons through the RO system and returned 250 gallons. So that is a 25% recovery rate.
And actually I was going to turn to column T next. That tells us that they were able to recover 250 gallons after processing 1,000 gallons, right?
Correct.
In column S, treatment description, it says, quote, entire treatment train, RO, main treatment of Entrada, PW for produced water at 10,000 TDS, treated to 500 TDS, comma, used on tree seedlings, close quote. Did I read that right?
Correct.
And it says treated to 500 TDS, past tense, correct?
True.
And it says used on tree seedlings, also in the past tense, right?
True.
Did the trees grow?
I don't know.
And looking at column K for the Canales project, NMED authorized this project 13 months ago, correct?
I'm sorry, this whole line of questioning is about a project that has not occurred yet. And so any inferences in those columns should not be made. This project is still in the design phase. Even it has not constructed. They have not placed water on any seedlings. I've been in contact. We've been in contact with the person who is doing this project, and we are still working through design
Mr. Herman,
aspects of it.
I understand what you're saying. I'm trying to test that information because the information that we have in this spreadsheet, which NMED has put together, indicates past tense use of words and says that the project has been completed. Correct?
Okay, so we may be able to then wrap up this line of questioning with one question, which is, regardless of the use of past tense, this project hasn't begun yet. The past tense is not appropriate here. Is that true?
Yes.
Okay, so I don't think we have to go through every cell to demonstrate the past tense should not have been used here.
So I guess my question then is, if this project has not begun, looking back to column Y, why does it say that the lab analysis has been completed?
My best guess, which is the greatest you can do in testimony, is that it was a transcription error into the spreadsheet or a data entry error, which does occur.
Now, just so I'm clear, Ms. Murphy, are you the individual who maintains this spreadsheet?
I am.
Did you make an error when you entered this data?
I believe that this is the lab analysis from the treated produced water, and it is run through the consortium's guidelines of the NPDES Plus list, the wet testing, and the NTA.
And that analysis has been completed?
And that the lab analysis has been completed.
Okay.
We don't have this lab analysis.
Yes, I understand that. Who oversees this project?
Can you clarify oversee?
Who's responsible for overseeing the data collection and turning the data over to the department?
It would be the entity that submitted the notice of intent.
Okay.
And the New Mexico Produced Water Research Consortium.
Okay. Has NMED entertained the possibility that the data is bad for produced water and it's not being shared with NMED because it would be harmful to the future use of produced water?
I have no reason to assume any of that.
I'm not going to go through all of these projects with you.
Thank you.
But there are a couple other red flags that I have to ask you about. Looking at project number 5, Tascosa Energy Partners Hydrosonics. NMED approved this project a year ago in May of 2023.
May I clarify that NMED does not approve projects.
The
We make a determination as to whether or not they would be discharging and within our authority.
And that then
Within our authority,
is what allows them to proceed with the project, correct?
pending they have all their other permits and determinations from other agencies, yes.
And the goal in that project was to take 3 samples and run risk and toxicology analyses and provide them to NMED, correct?
We'll let Ms. Murphy expand on that.
Sure.
Yes, it was an enhanced evaporation project.
Have you received the results and data set for even one of those samples?
So that project is under the jurisdiction of the OCD. And when that project went over there, they found out they needed to get a more complicated permit.
So you have not received any results or data set for even one of the samples?
No.
Now, there's been some discussion about the entities that are running these pilot projects. And I want to ask a couple of questions about the entities. Would that be best directed towards Ms. Murphy?
I think once we hear your questions and understand the content and the
Okay.
context, we can figure out who to direct that to.
Generally, the pilot projects are being run by LLCs and corporations, correct?
It looks to be that way, yeah.
And if something were to go wrong with the pilot projects, those LLCs and corporations would be liable for any damages caused.
I will hand that to Mr. Herman to answer.
Great, thank you.
It won't be exciting. I would much rather not speculate as to liability or a legal determination of who would be responsible for cleanup. It's not our area of expertise.
Generally, if there is a discharge that's unauthorized, the entity that discharged the effluent is responsible for the cleanup, correct?
That seems like a very simple question on the outset. I'll say generally that yes, that would be true.
Great. And then I pose this question to any of the members of the panel. Is NMED aware that any entity that conducts business in New Mexico is required to register with the Secretary of State and have a registered agent for the purpose of service of legal process?
Okay, this is objection. This is well beyond the scope of anyone's testimony.
Oops. Mr. Dodd.
Madam Hearing Examiner, part of this regulation discusses financial assurances for liability of cleanup and those sorts of things. And that's what I'm testing here because we've already had some of this activity going on. And I want to test to the extent to which NMED has already been making sure that these entities could be held liable here in the courts of New Mexico.
All right, so there's obviously one potential problem with that, which is that they can't give legal testimony, and they may or may not be able to answer the question at all. So, Ms. Fulham, why don't you either say whether the division can answer questions about financial assurance or not?
I don't believe any of the witnesses here have the ability to answer questions regarding financial assurance.
Okay, thank
Okay.
you.
But are you aware that 6 of the entities that have already conducted or proposed to conduct pilot projects here in New Mexico are not registered with the New Mexico Secretary of State?
I would not know.
Okay. And so NMED is not aware that Canales LLC, Solmem LLC, Zwitter Co., Z Nano Membranes, GC Solutions, and Sun Vapor are not businesses registered with the Secretary of State.
I do not look up these companies on the Secretary of State's website. I don't know. I don't look up businesses in general. I look for water quality.
Thank you, Ms. Fallman. I'd like to move more towards Mr. Herman now. Mr. Herman, first I want to talk to you about NMED's interactions with the consortium. Okay?
Yes.
In December of 2022, there was an external review audit of the New Mexico Produced Water Research Consortium, which addressed the organizational structure and leadership of the consortium, correct?
Yes.
The review team interviewed many stakeholders to evaluate whether the consortium was meeting its goals.
That was the instructions. I believe in the MOU attachment.
And you yourself were one of the individuals interviewed as an NMED stakeholder as part of the external review audit.
Correct.
And the external review audit was conducted by Jim Chavez, Senior of NMSU, Dr. Carrie Howe of Howe Water Science, and Dr. Duncan McBranch of Los Alamos National Labs, correct?
To the best of my recollection, those were the 3 people that interviewed me, yes.
Would it help refresh your recollection if you looked at their report?
I will agree to it, but I'd love a copy of it.
Great.
Yeah, can you provide an exhibit number for that?
Yes, and that's going to be exhibit NG14, which was NG14, which was filed with Norm Gown's rebuttal testimony, which is NEE Exhibit 4. And this particular report is contained at pages 80 to 94 of exhibit number 4. And actually, I have the hard copy for you, but I also have hard copies for members of the commission. And if we have enough for any party that may want one, these were uploaded to Dropbox, however. NG14. It's attached to his rebuttal testimony. It's NEE Exhibit 4. Mr. Herman, could you please turn to page 2? And I don't believe they're paginated, so you may just have to count the pages as we refer to them. I apologize for that.
I can get up to 2.
All right. Looking at the first bullet on page 2, could you please read that for us?
Sure. Stakeholders have differing expectations of the consortium and opinions of its progress to date. Industry seems to be generally satisfied with consortium, dialogue, and research, NMED is not. I'm sorry, that was unclear. NMED is not. The research resulting from the RFP has focused on technology development and thus far has not generated the data that is necessary for developing regulations.
And now, can we go to the fourth bullet on page 2? Could you please read that for us?
Sure. The organizational structure is not clearly defined, which leads to issues in reporting, accountability, and operations. This contributes to mismatches in expectations on research outcomes.
And the audit team concluded their letter portion of the audit by setting forth a summary on the 3rd page. Could you please read for us the 2nd paragraph on page 3?
Sure. In summary, the New Mexico State Legislature directed the NMED to develop regulations for the use of produced water outside the oil and gas industry, and the consortium is an essential contributor to that rulemaking process. It is unlikely that the consortium can accomplish its stated mission of generating the data needed to support the development of regulations if it has inadequate funding, an unclear organization structure, and lack of clarity in expectations in research and outcomes. The recommendations of the committee or some similar actions are needed if the consortium is to continue.
Thank you. And now, also attached to the letter was a PowerPoint exhibit. Could you turn to the 8th page of the packet?
Just to verify, is that key stakeholders were interviewed?
It is observations, titled observations.
I'm concerned about my ability to count now.
No worries. So you're on that page?
Observations.
In the 3rd major bullet, the independent external review team observed that there's a difference in expectations from stakeholder groups and opinions about its progress to date, correct?
Yes.
And the review team further found, quote, some don't appreciate the difficulty that NMED will have regulating this. PW, as in produced water, is a contentious issue. The public will complain no matter what NMED does. So they, NMED, have to have airtight science with chain of custody, peer review, no conflicts of interest, etc., to back up the regulatory process, close quote. Did I read that correctly?
Yes.
And the way that the review team obtained this information was through interviews conducted of NMED employees, correct?
Amongst other stakeholders.
Other people that they interviewed as well.
Yes.
But they would be getting information about NMED's concerns from NMED, correct?
I have no way of speculating on what anyone else said in those interviews.
Okay. Turning to page 10. And it's titled Observations Continued. I know it's complicated. The double-sided pages do not help. And the first words at the first bullet are the organizational structure. Are you there? I tried to make it as complicated as possible for you.
I like puzzles.
It's a cross-examination tactic. All right. So on page 10, actually, let me tell you which bullet to go to. Give me just 1 second. The fifth bullet, fifth minor bullet under the first major. The review team expressed concerns about issues of oversight, questioning, quote, who provides oversight to the industry-funded research to ensure that protocols are followed and the results are defensible? Is the research director supposed to do this? Is there a panel or advisory committee? Close quote. Did I read that correctly?
Yes.
Okay. To date, can NMED tell the commission who provides oversight for this research?
With any level of certainty, I don't want to say impression. My understanding is that Mike Hightower, as the director of the consortium, oversees the projects and the research.
Okay. Mr. Herman, I'd like to now shift over. You can put that exhibit away.
Thank you.
Oh, actually, just 1 second. Yeah, actually, can we go back? If you could just read the first major bullet for us on that same page.
Starts the organizational.
Yes.
The organizational structure is not clear, which leads to issues in reporting, accountability, and operations. This could be, and this is a parenthetical, this could be the source of issues on expectations and research validation.
And now turning to page 12. If you could read the first major bullet and the first minor bullet for us, please.
Just to verify, this is recommendations continued.
Correct.
I'm sorry, which bullets did you want me to?
The first major bullet and the first minor bullet.
Strengthen and clarify documentation and communication. Provide guidelines for research, documentation, and validation, parenthetical, RFP, research contracts, and parenthetical. What research was research completed and documented? How should it be communicated to NMED so it can be used in rulemaking?
Thank you, Mr. Herman. Are you aware of any organizational changes at the consortium in response to this report?
No.
Thank you. All right. Now I'd like to, we can put that one away. Thank you. I'd like to talk about NMED's understanding and interpretation of the Produced Water Act and the associated amendments to the Water Quality Act, okay? I believe that you are the right person on the panel to address this topic. Is that right?
I'll do my best.
Thank you. I'd like to look at the department's interpretation of the duties and jurisdiction of NMED and the commission, okay?
Is there an exhibit number? Or just in general?
I don't have the exhibit number here. I'm going to be referring to section 74-6-4P. And I apologize, I don't have the exhibit number.
74-6-4 subsection P.
Correct. And just let me know when you're ready. And I believe it's NMED Exhibit 16.
Got it.
Section P states that the commission, quote, shall adopt regulations to be administered by the Department of the Environment for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water, including disposition in road construction maintenance, roadway ice or dust control, or other construction, or in the application of treated produced water, or activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas. Did I read that correctly?
Yes.
Now, this subsection is a subsection of the Water Quality Act, correct?
Yes.
And I just want to clarify because there's been some question about the inclusion of the phrase, quote, for the disposition of treated produced water, close quote. Now, that does not mean that NMED and the commission only get to regulate the end uses of produced water, right?
Objection, that calls for a legal conclusion.
Yeah, to the extent you're asking them for a legal conclusion, I'll ask you to move on.
I'll rephrase the question. In drafting the proposed rule, was it NMED's interpretation of that language, quote, for the disposition of treated produced water, close quote, that the department only gets to regulate the end uses of produced water?
Well, I will start my response by saying that this rule is not intended to be a produced water rule. It's intended to be a reuse rule. And that is first and foremost that we were looking at drafting the rule for reuse through the Water Quality Act. I would say that I do not recall any discussions during the drafting process that directly answers your question. And so I think the answer is I don't know.
Okay. Now, NMED's interpretation of the use of produced water is that the use of produced water is considered, quote, disposition by use, close quote. Is that correct?
I'm going to ask if you could rephrase that. I'm not sure I understand your question.
Let me direct you to another subsection, okay?
Mm-hmm.
Section 70-13-4C. And I'll see if I can get you the
Exhibit 19.
I believe it is 19. That's correct. And it's subsection 4C. NMED Exhibit 19, Section 70-13-4C. All right, do you see that section?
Yes, sir.
Included within the language is, quote, the disposition of produced water, recycled water, or treated water, including disposition by use, is neither an appropriation of water for beneficial use under Chapter 72 NMSA 1978, nor a waste of water, and no water right shall be established by the disposition of produced water, recycled water, or treated water. Is it NMED's, sorry, did I read that correctly?
Yes.
Is it NMED's understanding of this statute that the use of produced water is a disposition of produced water?
Can I answer this?
Yes.
The section that you're reading is specific to the Office of the State Engineer, not to the Water Quality Control Commission. And the use of language and terms under the State Engineer are different than those under the Water Quality Act. So the terms that are being used in this section are not applicable under the WQCC.
Okay. So Ms. Fulham, you testified on direct, and this is going to be, give me 1 second. I'll find a site for your testimony. Give me just a moment. This is going to be your direct testimony, NMED Exhibit 2, at pages 17 to 18, beginning at line 22.
Okay.
You testified on direct that, quote, in 2019, shortly after the adoption of the Produced Water Act, NMED, EMNRD, and the OSC held several joint public presentations on produced water management, close quote. Is that correct?
Yes, that's correct.
And you referred to NMED Exhibit 61.
That's correct.
And that's the PowerPoint presentation that was presented at those meetings, correct?
I believe so, yes.
All right,
Yes,
now,
it is.
okay. I'd like to take a look at page 31 of NMED Exhibit 61, which is also Bates number 001814.
What page of that presentation? Sorry.
Page 31.
What is the role of the state engineer in
Yes.
produced water management? Okay,
And this was in a joint presentation of all three entities, correct?
correct.
And it was stated at that presentation, quote, the use of produced water is considered disposition by use, correct?
As it pertains to the Office of the State Engineer.
Does it say that in the section that I read?
It says, what is the role of the Office of the State Engineer in produced water management? So yes,
And you would agree that the Produced Water Act was a comprehensive regulation or comprehensive piece of legislation
I couldn't speak to that.
to oversee produced water in New Mexico, correct?
I couldn't state whether it's comprehensive or not.
You would agree that the section to which I was referring earlier, section 70-13-4C, is contained within the Produced Water Act, correct?
Correct, that's within the Produced Water Act.
And so I want to go back to Mr. Herman. Mr. Herman, is it NMED's understanding that NMED has complete authority and jurisdiction to regulate all discharge, handling, transport, storage, recycling, or treatment of produced water for activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas?
Objection calls for a legal conclusion. I mean, if we're going to be interpreting statutes, we need attorneys to do that. These are technical witnesses.
Right. So, Mr. Dodd, I mean, you're going to have a chance to make legal arguments as part of your closing submittal.
Could I respond briefly, please?
Yes.
I just want to say, I'm asking what NMED's understanding of their statutory role is when crafting these regulations. And so I think that that's relevant to these proceedings because what they understand their power to be then influences the regulations that they then promulgate and that they've proposed to this commission.
Okay. So, but then what is your ultimate question? That is to say, would it be better, I'm trying to be helpful, to turn it around and ask what they would consider outside their scope? Is there something in particular that you want them to confirm?
Yes, I want to ask about what they can do with regards to produced water. So I can jump just to that.
Okay.
So first of all, NMED's understanding of this regulation, of this statutory scheme, says that, does not say, sorry, that you have to allow the discharge of produced water, correct?
I do not, my understanding of the Produced Water Act is that it does not mandate NMED to issue discharge permits for produced water.
And in fact, that's why NMED has been able to bring forward a regulation or a proposed rule that prohibits the discharge of produced water, right?
I think in part, yes.
And similarly, this is what I want to understand. Does NMED take the position, when it was crafting this proposed rule, was it NMED's understanding that it can propose regulations that would prohibit the handling of produced water off of the oil field?
Can you repeat the question, please?
When this regulation was being promulgated, was it NMED's understanding that it could prohibit the handling of produced water off of the oil field?
Again, I think that NMED, us as technical staff, would rely on our Office of General Counsel to provide us direction as to where that authority lies. I don't believe that that is part of our proposed rule.
Yeah, I think that the rule that we proposed is within the authority of the department and the Produced Water Act and the Water Quality Act.
Okay. Would you have proposed a rule that prohibited the handling of produced water outside the oil field?
Okay,
Objection
that-
asked and answered.
Right. I'm sustaining the objection. You continue to try to draw them out on what they speculate as to what their authority might be. And that's not for them.
The reason that NMED has decided to prohibit discharges of produced water is because there is insufficient data and evidence that discharges would be safe for the environment and public health and safety, correct?
They've given that testimony at least 3 times that I remember, twice during this cross an hour ago. They've already, you opened with that testimony. You've already had them confirm that. Do you have other topics?
I do. When NMED was promulgating this rule, this proposed rule, it was under the understanding that the Water Quality Act requires credible scientific evidence when promulgating regulations, correct?
Incorrect.
Could you please explain?
Yes, I can. First, NMED does not promulgate regulations. We petition for proposed regulations for the commission to adopt and then promulgate. Second, regulations do not require scientific evidence to be adopted. In the Water Quality Act, it specifically states that standards require defensible scientific evidence. Regulations are not standards.
Okay, thank you for clarifying.
You're welcome.
One of the things that NMED looked at when coming up with this proposed rule was the character and degree of injury to or interference with health, welfare, environment, and property, correct?
Correct.
Now, did NMED consider the best available scientific information?
I believe so.
Would you agree that any handling, transportation, storage, recycling, and treatment of produced water off of the oil fields involves a degree of risk of releases and spills.
I can only speak to the protection of groundwater quality.
And wouldn't releases and spills potentially damage groundwater quality?
I believe our proposed regulations refer back to 20.6.2.1201, which is for the release of contaminants that are reportable to the department.
And so does NMED agree that the handling, transportation, storage, recycling, and treatment of produced water off of the oil fields involves some degree of risk of
Yep.
contamination of groundwater?
If there was a spill, it would be required to be reported under our current regulations, with or without these regulations.
I understand that it would be required to be reported, but the question that I'm asking is, would handling of produced water off of the oil fields involve a degree of risk of releases and spills that could impact groundwater quality?
Has anyone on this panel testified about the handling of produced
No.
water on the oil fields?
No.
Or you're not even qualified to give that testimony?
No. That's what I'm
This
struggling with.
is, this is not the panel to ask that of.
Madam Hearing Examiner, I'm asking if NMED has looked at the risks of handling produced water off of the oil fields, not on the oil fields. Maybe I misspoke.
Okay, so you didn't ask it that way, whether that was part of what they looked at on the way to drafting the regulation. You just asked them to confirm that it was a true statement.
Okay.
So you can ask that part.
Did NMED consider the risk that releases and spills from the handling of produced water off of the oil fields might pose to groundwater?
To the extent necessary for drafting the rule as we did with the prohibition. Sorry, to the extent, lost my train of thought, sorry. To the extent necessary for drafting the rule as we did, yes.
And so NMED was aware that in 2020, there were 714 spills of produced water on the oil fields, right?
I do not recall testifying to that or any of my panel members testifying to that.
So I direct you to NMED Exhibit 37 at page 10.
We are on page 10.
Do you see table 2-4?
Were you talking about the BLM water support document for oil and gas
Correct.
on
Oh.
page 10?
Page
Bottom
10.
number, not page
Table 2-4.
okay. We have that page.
Okay. In that table, there is a row that says produced water, correct?
Yes.
And just to clarify, this table is a summary of 2020 spills in the state of New Mexico within the oil and gas industry, right?
Yes.
And in the produced water spill count column, it states that there were 714 spills of produced water on the oil fields in 2020, correct?
Yes.
And those 714 spills involved 65,176 barrels of produced water.
Yes.
And there are 42 gallons in a barrel, correct?
Yes.
You don't have to do the math, but will you trust me that that's over 2.7 million gallons of spilled produced water?
I trust you.
Thank you. Did NMED consider what would happen if 2.7 million gallons of produced water were spilled outside of the oil fields in New Mexico?
This table was not used in the development or drafting of the regulations.
And so NMED did not consider what would happen if 2.7 million gallons of produced water were spilled throughout the state of New Mexico off of the oil fields. Is that right?
We considered spills as a potential, but not that specific number from this specific source.
What would happen if 2.7 million gallons of produced water were spilled into the Rio Grande River?
Beyond the scope.
Yeah, Mr. Dodd. Beyond the scope of their testimony.
And I just would like to briefly respond, please. Madam Hearing Officer, I'm trying to test the degree to which NMED evaluated risk posed to off oil field, or risk posed by off oil field use and transportation of produced water. And I think that this question goes to that. And this panel is here to testify on behalf of NMED in support of a rule that would permit the transportation of produced water throughout the state off of the oil field.
All right. I still don't think that the question as to what would happen with, I think you said 2.7 million gallons of water into the Rio Grande is something that they came here prepared to discuss.
Okay. Mr. Herman, I just have one other question, okay? NMED would agree that decision makers who have the responsibility for protecting people and the environment need to weigh potential benefits and risks posed by produced water use, correct?
And I will speak for myself as an employee of NMED. Yes.
Thank you. I'd like to move to my questioning of Ms. Lucas Kamal. Is that right? Ms. Lucas Kamal, I'd like to talk with you about this notice of intent process for produced water demonstration projects. Would that be okay?
I did not testify to the notice of intent process for produced water. It's not part of 401 certification.
Okay. Who would I better direct these questions to? Ms. Fulham or Ms. Murphy?
I can try and answer if you can repeat the question.
Okay. I want to talk about the notice of intent process for produced water demonstration projects and industrial projects. And that's under subsection 400 of the proposed rule, correct?
Correct.
So an applicant, the words are weird, okay? Let me just say the person proposing a project needs to obtain a determination of no discharge permit needed before they can use produced water, correct?
I will be okay with your description. Yes.
Okay, you agree with that?
Sure.
Okay. And the person who's proposing a project obtains such a determination by submitting a produced water NOI.
Correct.
And in the NOI, the person proposing the project must provide the information that's set forth in subsections or subsection C1A, correct?
We've talked about so many things today.
I know. I apologize.
C1A, yes.
Okay. I want to ask, what is the applicable definition of discharge for this rule? I couldn't find a definition for that term anywhere in the statutes or regulations, and I thought that you might know.
There is no definition for discharge, and Mr. Herman is the best to speak to that.
Mr. Herman, what is the definition of discharge, if any, for this portion?
Sure. There is no definition for discharge in the Water Quality Act, Produced Water Act 20.6.2 or 20.6.4. It is a term that has evolved over the decades of implementation of these regulations. And if you, it oftentimes confuses people that activities that would traditionally not be considered a discharge, we would define as a permitting program a discharge. We would define it as a discharge.
Could you give me a couple of examples of some things that pose, that cause some confusion?
Sure. In the instances of double-lined synthetic impoundments with leak detection systems, we consider that a discharge. It reverses the idea in most people's minds that a discharge is some sort of activity that would move, but we work off of potential for discharge in order to ensure that we're being protective. So in that example, double-lined synthetic impoundment with leak detection has the potential still to affect groundwater, and therefore we would require a discharge permit for. Another example would be a very high level radioactive liquid waste treatment system that was fully contained, has zero discharge, and only transports any type of effluent to the waste isolation pilot project, is still considered a potential for discharge to ground or surface water, and therefore would require a discharge permit.
So let me see if I can clarify a little bit for my own edification. If there is any potential for discharge, then it's considered a discharge?
I would agree with your statement, except for the word any.
Please clarify.
It's a, I don't want to use the word judgment, but it is a determination that the department makes that the potential is to the extent that would require a discharge permit with monitoring conditions. So oftentimes a discharge permit is required when, with the easy ones, the double synthetic liner with leak detection, that there's a potential for failure of that liner, and we have evidence that a liner or a double liner or the leak detection has failed in instances, and we have therefore decided that potential there was enough to require a discharge permit.
Okay. I'm not sure that totally clarifies it for me, but it sounds like it isn't really a clear thing. It depends on the situation and the circumstances.
It does. It depends not just on the technology, the equipment, the methods, but it also depends upon the site. So a site that has more than 1,000 or 1,300 feet to groundwater is treated differently than one that is 50 feet to groundwater or 5 feet to groundwater. There's a multitude of factors that would go into a determination as to whether or not there was a potential.
Can I add clarification though?
Please, Ms. Fuller.
When we're talking about lagoons and impoundments, they have the potential, lagoons and impoundments, they have the potential to discharge and would be required to have a discharge permit. So they would not be one of those. There's no ifs, ands, or buts on lagoons and impoundments. The conditions that are in the discharge permit and the potential risk to groundwater decreases depending or increases depending on depth to groundwater and site-specific conditions. I just want to make it clear that those determinations, a line lagoon, a clay line lagoon, double synthetic liner with leak detection, they all require discharge permits, to make that clear for you.
Okay. What about a tanker truck traveling down a highway? Would that require a discharge permit?
As far as I know, the Water Quality Act and the Water Quality Control Commission does not develop the regulations for the Department of Transportation. But again, this is again going into an area in which our staff and part of this regulation do not address, and so we're not prepared to testify to.
Well, let me clarify a little bit then.
And we'll need a break soon, Mr. Dodd.
Okay. This rule proposes to allow research of unproduced water outside of the oil fields, correct?
Correct.
The water has to get to the research facility in some manner, correct?
Correct.
And so whether there's going to be a discharge or not determines or is determined in part by the manner in which it is transported, correct?
I would disagree with that. There is another half to this regulatory authority, and that involves OCD. There is transportation of produced water every single day under OCD. I don't believe that this rule even crosses that boundary.
Even if the produced water is being transported off of the oil fields out of the jurisdiction of OCD, are you saying that NMED is not going to regulate that activity?
We have regulations, which I think I've already testified to under 20.6.2 regarding incidental releases and discharges without a permit, which that if there were to be an accident, spill, or incident involving a trucker and it were to release something, we have surface water and groundwater who respond to all spills of contaminants, whether that be produced water or other contaminants. And it gets divvied out. I think it's beyond the scope of this testimony, but it gets divvied out between the different bureaus within NMED, Department of Transportation, State Police, and Incident Command. Can go on, but there are provisions already in place for any spill or release, whether it to be groundwater or surface water. So I'm uncertain if that's not sufficient for your understanding or if you need more detail on that.
Well, doesn't the NOI require that the NOI proponent give you information about the transport and handling of produced water?
A plan, so in section C1(8), it requires a plan to transport in and transport out of any untreated produced water or treated produced water in a safe manner in accordance with state and federal regulations.
And so NMED would look at the transport plan, and if it looks like it will result in a discharge, what is the NMED going to do?
I'm visualizing because I'm struggling with where you're trying to lead us to say. I mean, if they say that they're going to put it in a semi truck with the back end open, yeah, we would most definitely say that would be a discharge. And if they're preemptively telling us they're going to let it leak out the back of the truck, there's going to be a prohibition of that. That's part of this is that they cannot get a discharge permit, they cannot discharge, and telling us they're letting it leak out the back of the truck would be admission of a discharge. If it were to be incidental or accidental, it would fall under 20.6.2, and they would have the reporting requirements just like every other contaminant that's accidentally released. Are we getting to?
I think we ought to take a break now.
Okay, I would agree.
Yeah, it's been more than 90 minutes. Let's take 10 minutes. All right, we have less than an hour left together. Ms. Nanasi, I see you in the examiner's seat over there.
Yes, thank you. For the record, my name is Marielle Nanasi with New Energy Economy, and I will be questioning Dr. Hu.
Okay, thank you.
Good afternoon, Dr. Hu.
Good afternoon.
You have reviewed and are familiar with current peer-reviewed scientific studies with regard to practices and challenges, including risks for produced water treatment and reuse, correct?
Yes, I reviewed a lot of paper regarding the produced water treatment toxicity assessment.
You co-authored the characterization of produced water in the Permian Basin for potential beneficial use.
Can
And
you
that,
repeat? Sorry.
and that was in 2022, appeared in the New Mexico Water Resources Research Institute Technical Completion Report number 398, correct?
Yes, correct.
Even though you co-authored that scientific report, it is not included in NMED's filing, correct?
Yes.
But New Energy Economy did include your report that you helped co-author as in New Energy Economy Exhibit 4, the rebuttal technical testimony of Norman Gaum as Exhibit NG18, correct?
I'm sorry, I'm not seeing that exhibit. Was it put in the Dropbox as a demonstrative exhibit? It was filed.
If I may answer,
please.
It is in the Dropbox. It's in the Dropbox as New Energy Economy Exhibit 4. I do have a copy. And then there's exhibits with Mr. Gaum's rebuttal. And this is NG18. And I do have a copy if I can approach.
I think that would help.
Ms. Jones, might you be able to pull that up on the screen? Well, I sent it to you, and my title on it is called February 2022 Characterization of. Okay. You have that before you, correct?
Yes. Yes.
And you were a co-author of that report, correct?
Yes.
I've highlighted certain portions that I'd like to talk to you about so it could streamline the process. This technical report is from February 2022, correct?
Yes.
Ms. Jones, could you please go to the highlighted portion on page 2? No, actually the number page 2. Thank you. Okay. Thank you. Typically, PW, or as it is known in your report as produced water. It's known as produced water in your report, correct?
Yes.
Okay. Typically, produced water is highly saline and could contain many different constituents, such as suspended particles, dissolved mineral salts, organic compounds, for example, volatile and semi-volatile organic compounds, VOCs and SVOCs, petroleum, hydrocarbons, organic acids, and oils, naturally occurring radioactive material, NORM, other inorganic constituents, for example, sulfide and ammonia, chemical additives, and their transformational byproducts during well treatment or from the interactions with formation water. Extensive treatment is required to remove these constituents for safe reuse of treated produced water, which can include settling, media, filtration, coagulation, chemical precipitation, adsorption, biological treatment, membrane desalination, thermal distillation, and advanced oxidation processes. Other than not reading the sites, did I read that correctly?
You did.
Then it continues. One of the barriers to using treated produced water as an alternative water source is the lack of comprehensive characterization of produced water quality. Did I read that correctly?
Yes.
And then if you go to the last highlight on that same page, the Permian Basin in southeastern New Mexico and western Texas is the most productive oil province in the U.S. and accounted for almost 60% of onshore oil production in July 2021. However, there are limited studies focused on the characterization.
I'm sorry. Would you, it's too loud?
Okay, thank you.
Thank you.
So I'm just going to start from however. However, there are limited studies focused on the characterization of produced water in the Permian Basin, especially the produced water from unconventional wells. Is that correct?
Yes.
You and your co-authors wrote what I just read, correct?
Yes, I'm a co-author of this report, but I actually didn't write this sentence, but I agree with that. Yeah.
But you did what?
Agree with the opinion, the factors.
Okay, so you agree with the opinion even though you didn't write those specific sentences.
Yes.
Could you please, Ms. Jones, scroll to page 3? The highlighted portion there reads, thus, comprehensive chemical characterization and risk assessment of produced water is necessary for potential treatment and beneficial use outside the oil and gas field in the Permian Basin. Did I read that correctly?
Yes, correct.
You would agree that the comprehensive characterization of Permian Basin produced water is scant, and what I just read is an accurate account of the state of science today, just as it was in 2022 when this technical report was completed, right?
Can you repeat your question?
You would agree that the comprehensive characterization of Permian Basin produced water is scant, meaning there's not a lot of it. And what I just read, is an accurate account of the state of science today, just as it was in 2022 when this technical report that you authored was completed. Ms. Jones, can we please go to page 12? I'm going to read that highlighted portion as well. Currently, there is very little data or other information regarding NORM, that's N-O-R-M capitalized, in Permian Basin produced water. 9 of the produced water temporal samples were analyzed for NORM, RA, which stands for radium, correct?
Correct.
RA 226 with a half-life of 1,500 years, and RA 228 with a half-life of 5.75 years were chosen because they are the most abundant. The results show that the RA, which is a combination of RA 226 and RA 228, has an average level of 109.5 picocuries per liter, which is much higher than the EPA regulatory limit of 5 picocuries per liter for drinking water. Did I read that correctly?
Correct.
And then on the bottom of the page, turning to the next one, Ms. Jones, if you would. Thank you. Currently,
Ms. Nasi, what we've been able to see, even though Ms. Jones has been going to the pages you've identified, we haven't seen highlighting except the first time. So continue down to page 13, Pam. And let's see if there's highlighting here. No. So if you tell us what paragraph you're looking
okay,
at.
it's the first paragraph.
Okay, thank you.
I'm sorry about that. I don't know. Currently, there is limited data or information regarding the presence of NORM in Permian Basin produced water. Radium 226 and 228, uranium 234 and 238, thorium 228 and 230, polonium 210, and plutonium 238 were detected in the samples. In contrast, neptunium 237, americium 241, uranium 235, thorium 232, and plutonium 239 and 240 were not detected. RA 226 half-lives of 1,600 years and radium 228 half-lives of 5.75 years were chosen for comparison because they are the most abundant and most widely detected in other basins and represent the first soluble daughter product in the uranium-238 and thorium-232 decay chains, respectively. Results show total radium-226 and radium-228 has a mean level of 469.3 picocuries per liter. Is that correct?
Correct.
The concentrations of radioactive material is almost 100 times the water supply criterion in the state's standards for interstate and intrastate surface waters, codified at 20.6.4 NMAC. Is that correct?
Yes, it's a statement in my testimony.
You are aware, are you not? Exposure to radium can cause a number of health problems, including cancer, especially bone cancer, liver cancer, and breast cancer, anemia, which is a decreased ability of the blood to transport oxygen, cataracts or growth in the eyes, broken teeth or cavities. Radium can reduce bone growth or necrosis of the jaw, and radium can be an immune system depressant. Are you aware that those are the effects if someone is to be exposed to radium?
I know over some concentration, when the concentration beyond the limit, it will pose a risk to human health.
Thank you.
Yeah.
Ms. Jones, could you please scroll to page 17? Yes, thank you. In the first paragraph, in the copy that I gave you, and I apologize to the commission, I highlighted something that I'd like to read. Detected VOCs include benzene, minimum to maximum 1900 to 4900 micrograms per liter, toluene 1700 to 3700 micrograms per liter, ethyl benzene 72 to 160 micrograms per liter, and xylene 710 to 1600 micrograms per liter. That together is often referred to as BTEX, B-T-E-X, of which benzene, toluene, and xylene had the highest relative abundances. Results are consistent with other studies and are anticipated because these compounds are closely related to oil and gas production. Dr. Q, did I read that correctly?
Correct.
Dr. Q, you would agree that exposure to VOC vapors can cause a variety of health effects, including eye, nose, and throat irritation, headaches, and loss of coordination, nausea, and damage to the liver, kidneys, or central nervous system.
Same answer is not the question. When the concentration beyond the limit, I need to check the limit. It will pose a risk to human health.
And prolonged exposure to VOCs or repeated exposures to VOCs may contribute to even more serious health problems, especially with individuals who have lung disease. Is that also true?
I think so.
And Ms. Jones, this is the last reading from this report. Thank you. Ms. Jones, could you please turn to page 25? Thank you kindly. I'm going to be reading from the first paragraph, which is 3.6 under the title Acute and Chronic Toxicity. The high salinity of produced water was considered as a major mechanistic mode of toxicity for exposed organisms. In addition, other potentially harmful chemical species present in produced water, including organic petroleum-related hydrocarbon species, for example, PAHS, heavy metals, lead, arsenic, nickel, radionuclides, and industrial fracturing additives such as biocides, surfactants, SURFACTANTS, and polymers may also contribute to the whole toxicity of produced water. Thus, to properly assess risk, having an a priori understanding of the ecotoxicity effects of produced water to different organisms is necessary for both risk management and helping to define the most toxic components and necessary treatment strategies prior to produced water discharge and reuse. Did I read that correctly?
Correct.
Dr. Hugh, you note in your testimony that there are over 1,100 chemicals identified in produced water, correct?
Can you give me a reference? Which page? Which testimony?
I'm pretty sure it's your direct, and I'll get you that. Actually, my co-counsel is going to help me with that, so we're going to move on, and I'll come back to it when I have the exact page number. The one page number I don't write down, and you asked me about it. Okay, so now there is a version of this report that you wrote. It's a similar version that appeared as NMED Exhibit 140 that you cited in your testimony. Is that correct?
You mean, what's the exact number?
If Ms. Jones, if you wouldn't mind, please bringing up the Journal of Hazardous Material. And the Bates stamp number is 3928.
Yes, I included this paper in my testimony.
And this is very similar to the characterization of produced water in the Permian Basin for potential beneficial use that we have been talking about.
Actually, there are two different products. So for this paper, it's a peer-reviewed paper. I mean, I included this peer-reviewed paper in my testimony. And the next one is a technical report. So I'm on co-author of this technical report, but I'm not on co-author on this paper. That's my clarification.
Thank you.
Yeah.
Thank you. I appreciate that clarification. But you're familiar with this report because you cited it in your testimony, right?
On this paper, I cited it in my testimony, but I didn't cite this technical report in my testimony.
Right. So I just want to go back to that one question that I asked you before. And it is in your direct testimony, which is Exhibit 5, page 9, Bates stamp number 123. And the question I asked you was, you note in your testimony that there are over 1,100 chemicals identified in produced water. And the exact quote from your testimony is that there is a total of 1,198 chemicals have been identified in produced water. Is that correct?
This number is from literature review paper. It's from a review paper.
It's from a peer-reviewed paper, correct?
Yeah, but that paper is a literature review paper. It's not a research paper.
It's a literature
Yeah,
review.
it doesn't mean there are 1,200 chemicals in one produced water sample.
Now going back to New Mexico Environment Department Exhibit 140, which is Bates stamp 3928. Ms. Jones, can you move it down a little bit? And does this have under that like map there that's showing on the screen? Okay, that is the abstract. And I'd like to read to you 2 parts from that abstract. This study provides the first step to better understand produced water quality to develop beneficial reuse programs that are protective of human health and the environment. Do you see that second sentence of the abstract?
Yes,
Did I read that correctly?
correct.
Okay, somewhere in the middle there's another sentence that begins with PW samples, which stands for produced water samples, correct?
Correct.
Produced water samples had total dissolved solids, TDS, concentration ranging from 100,800 to 201,500 milligrams per liter. Did I read that correctly?
Correct.
Various mineral salts, metals, oil, and grease, volatile and semi-volatile organic compounds, radionuclides, ammonia, hydraulic fracturing additives, and per and polyfluoroalkyl substances. I'll spell that for the record. POLYFLUOR, excuse me, OALKYL. Substances were detected at different concentrations. Is that correct?
Yes. And the last word means PFAS.
That's exactly what I was going to ask you.
Yeah.
So that very long word that I couldn't say so well is often referred to as PFAS, capital P, capital F, capital A, capital S. Is that right?
Yes.
Okay. Could you please now go to the PFAS section of this report, which is on Bates stamp number 3935. And Ms. Jones, may I ask if you would go to that section in this report, which is section 3.4. Yes, and it is on Bates stamp page 3935. So Dr. Hugh, when you did the characterization, when you wrote this characterization of produced water in the Permian Basin for potential beneficial use. Was there a discussion of PFAS in this report?
Actually, I don't know, because for this technical report, I contributed to two parts. The 3.5, the microbial community analysis, 3.6, accurate and caloric toxicity. So for the chemical analysis, I didn't do any contribution from that. So
Okay.
I
But-
cannot recall.
But in this report that is peer reviewed, that relies on the same data, right?
I believe so.
This technical report, excuse me, this peer reviewed report, scientific report that appeared in the Journal of Hazardous Materials has a whole section about PFAS and the findings of PFAS in the produced water in the Permian Basin, correct?
Correct.
Actually, it's the only study right now that we know of that talks about produced water in the Permian Basin and findings of PFAS. Is that also correct?
I believe so, because I think I have this statement in my testimony.
So if we could now go to the very first paragraph. And I'd like to read the third sentence there. PFAS can accumulate or concentrate in the environment and may have the potential to cause adverse health effects. The US EPA established the lifetime health advisory levels of 70 nanograms per liter for combined, and I'm going to spell this, PER dash FLUOR OOCTANESULFONIC acid, which is referred to as PFOS, and I'm going to spell this again, PERFLUOROOCTANOIC acid, which is referred to as PFOA, concentrations in drinking water. So did I read that right?
Yes.
And if you go to the next column, in the middle, it says 5 PFAS compounds were detected in the produced water sample. And at the end of that column on the right, it says identification of these substances is challenging due to trade secret or proprietary information. Further non-target and target analytical methods can be utilized to characterize these substances in produced water. Did I read that correctly?
Correct.
Dr. Hugh, are you familiar with the fact that California requires that any produced water reuse requires the disclosure of all chemical additives, and that there is, that if a producer doesn't disclose them, that is subject to penalty?
No.
Now, if you could go to the next page, Ms. Jones. The conclusion of this PFAS section says, importantly, more analyses of diverse samples are needed. Do you see that?
Yes.
I believe you said in your direct, understanding the amount of total dissolved solids in produced water is crucial for management of produced water, correct?
Yes,
And it, just like what we've been reading, you also said that some Permian Basin produced water has as much as 201,000 micrograms per liter.
what's your question?
That's what you testified to in your direct. Is that right?
You mean the TDS concentration? Yes.
Of all the things that I've read from this report, this scientific report that you included in your testimony, you agree with those conclusions, correct?
Yes.
Okay. I have one more report to go over with you. And Ms. Jones, would you please bring up analysis of regulatory framework for produced water management and reuse in major oil and gas producing regions in the United States? It's no, maybe I didn't send this to you. Analysis of regulatory framework. Okay. And this is in the record as New Energy Economy Exhibit 4, Norman Gaum, Exhibit 20. So all parties should have it. And this scientific report, have you ever seen this report?
It's a peer-reviewed paper.
Yes.
Yeah.
Have you seen this before?
Yes. Yes. I have this in hand.
And Dr. Pei Xu, P-E-I-X-U, was one of the authors of this report, scientific peer-reviewed report.
Yes.
And she is the associate director of the consortium.
Yes.
And this was not included in the NMED's filing, 5,500 plus pages. This was not included, right?
I didn't include this paper in my testimony, but I'm not sure for other witnesses.
And this is entitled Analysis of Regulatory Framework for Produced Water Management and Reuse in Major Oil and Gas Producing Regions in the United States. And this was from July 2022. Correct?
Correct.
On the first page, near the bottom, right there. It says, given the complexity surrounding produced water regulations and rules, this study is intended as preliminary guidance for produced water management and for identifying the knowledge gaps and research needs to reduce the potential impacts of treated produced water reuse on the environment and public health. Did I read that correctly?
Correct.
Now, if you could go to page 26 of this same paper. Again, this is attached to New Energy Economy Exhibit 4, which is Norman Gaum's testimony, and it's his Exhibit 20. I'd like to read a couple of parts that are highlighted there, but not, I think maybe, let's see if they're highlighted here. It's on the right, top right-hand corner. It says 26 of 33. It's good. The treatment effectiveness for removing the chemical constituents in produced water needs to be demonstrated to protect the environment and public health during beneficial use. Because of varying levels of oil residues, salts, suspended solids, petroleum hydrocarbons, metals, NORM, NORM capitalized, and other chemicals and potential toxins, produced water must be treated to meet the water quality requirements for fit for purpose uses. There are many produced water pre-treatment and treatment processes available that include modular and scalable components. However, current treatment technologies are often not cost competitive as compared to the options of SWD, well disposal, or water reuse, or HF. Did I read that correctly? SWD is saltwater disposal, right?
Yes,
And HF is hydraulic fracturing, correct?
correct.
And then if you go down further to that other highlighted portion, it says, as manufacturers are unwilling to reveal key details about the chemical additives due to trade secrets, it makes it difficult to identify these chemicals and assess their associated risks during reuse. For risks and toxicology assessment, it is imperative that the chemical additives be disclosed as well as the volume and frequency of their use. Did I read that correctly?
Yes,
And you would agree with that, right?
to my knowledge, I agree with that.
And then if you go to just the very next page, and yeah, I'll start with that first highlighted portion. Up to date, there are limited studies and no established tools to monitor these unknown transformation compounds and understand the toxicity effects of the chemical interactions during reuse applications. Did I read that correctly, Dr.
Correct.
Pugh?
Correct.
If you go down to the last highlighted portion, the risks associated with reusing treated produced water still require intensive research. Given produced water is a new, non-traditional water source, and the water chemistry is complex with naturally occurring constituents and chemical additions during the well stimulation process. Water quality standards for different reuse applications should consider the known and unknown chemicals and toxicological characteristics of produced water and treated produced water. Intensive research is needed to provide scientific and technical knowledge to establish science-based regulations and develop well-informed permitting programs for the safe reuse of treated produced water outside of the oil and gas fields. Did I read that correctly?
Yes,
And do you agree with that statement, Dr. Hugh?
yes, I agree with this.
No further questions.
Fine, thank you very much, Ms. Nanasi. Ms. Fox, we still have a little bit of time together. Sorry, what?
Madam Hearing Officer, I did have a few last questions for Ms. Murphy.
Oh, for Ms. Murphy.
Yes.
Okay, I'm sorry, Ms. Fox.
I apologize.
Okay.
Ms. Murphy, I'd like to discuss the difference between bench scale projects, pilot projects, and industrial projects. Okay?
Yes.
Bench scale projects are tightly controlled lab-based scientific studies. Is that right?
Bench scale project means a project or study conducted in a lab.
Okay. Pilot projects are field science that's on a bigger scale than can be done inside of a lab, correct?
Yes.
Bench scale projects and pilot projects are the basic scientific procedures for how you study produced water, correct?
Correct.
And generally, you use bench scale projects to characterize the produced water, figure out what's in it, test hypotheses about how you might remove those contaminants. Is that right?
In a lab.
And that includes attempts at treatment and confirmatory testing, documentation, publication, peer review, that sort of thing, correct?
It could be. It's a definition.
Okay. And then pilot projects are used to take those lab tested hypotheses and findings to see if they hold up at a more real world scale, correct?
A larger scale. Yes.
It's still a controlled environment, but it's bigger. Is that right?
Yes.
And in pilot projects, you can evaluate cost effectiveness and feasibility at that larger scale, right?
Yes.
Now, based on NMED's testimony, you would agree that we need to do more scientific research before exposing humans, animals, and the environment to produced water, right?
Yes.
However, despite this concern and not having fully characterized produced water and how it might be treated, NMED's proposed rule allows for the use of produced water in industrial projects, correct?
Yes.
Doesn't the potential use of produced water in industrial projects as allowed under the proposed rule cause concern for health, safety, and the environment?
An industrial project does not discharge.
But that wasn't my question, right? My question was whether the use of produced water in industrial projects causes concern for health, safety, and the environment.
I'm sorry, I'm going to jump in. Within the scope of the rule, we would argue no.
I'd like to go back to Ms. Murphy with this question. Ms. Murphy, you would agree that industrial projects are large scale, correct?
I agree that they probably are.
You would agree that there are potentially lots of workers working at industrial projects, correct?
It could be.
You would agree that those workers might be exposed to produced water during the operation of the industrial projects, correct?
It very well could be.
There are also potentially huge amounts of produced water used in industrial projects, correct?
I suspect that's true, but I don't necessarily know.
Are you not concerned that the workers working on these industrial projects could become sick if they are exposed to the produced water?
I'm sorry, no one testified to this, and this is outside the
Madam
scope of this
Hearing
rule.
Madam Hearing Officer, I
Ms.
would object to the witnesses posing legal objections.
All right, it's just the line's been crossed quite a bit during this cross exam. So Mr. Dodd, not one of them testified to worker safety. I have to ask you to move on.
Ms. Murphy, has NMED considered that there could be a major failure at an industrial project that could result in enormous amounts of produced water being released into the environment?
I believe this is beyond my testimony.
And so nowhere in your testimony is it addressed that there's some risk of this?
No.
And so without having considered the risks posed by industrial projects to the environment and health and safety, how can we be ready for industrial projects to be authorized under this rule?
I think others may have more experience with industrial discharge projects, so they would know what cooling water and process and boiler feeds are.
Were there other members of the panel that testified as to the risks posed by industrial projects to health, safety, and the environment?
I'm going to try and answer your question so that we can move on with this. When we develop regulations for the protection of ground and surface waters, we do take into account the threats as it pertains to ground and surface waters to human health and the environment. This rule, we believe, as proposed, has taken those considerations into account.
Okay.
And it is reflected in all of our testimony.
And so, Ms. Fulham, can you please direct me to where in the testimony the risks associated with large-scale industrial projects is discussed?
I cannot cite anything at this point in time. If you can point to my testimony, I'd be glad to discuss it. We have discussed ad nauseum the threats that produced water and the lack of research on produced water has posed, and why this rule would be prohibitive to prevent discharges of such water.
Would you be surprised to hear that I can't find a single place in your testimony where it discusses your testimony or the testimony of any of the members of the panel that discusses the risks posed to health, safety, and the environment by large-scale industrial projects?
That statement, as you specifically quoted, probably is not in our testimony.
Would you be surprised to learn that nowhere in NMED's testimony there is any discussion of potential risk of accidental discharges or releases from large-scale industrial projects?
I would disagree with that. There are provisions in the general section of this regulation for all reuse, that all the requirements in 20.6.2, and I'd like to clarify for the record, it's 1203. I think I might have said 1201 earlier, under section 1203, which requires reporting of spills and releases.
That was not my question, however. My question was, would you be surprised to learn that nowhere in the testimony of any of NMED's witnesses is the potential for accidental discharges and the risk thereof from large-scale industrial projects discussed?
No.
Thank you very much. I have no further questions.
All right. Thank you, Mr. Dodd. That will complete our technical case today. We will resume with public comment at 9. Following public comment, we'll hear from Ms. Fox, any redirect by Mr. Knight, and then we will move directly to Mr. Hightower, who has agreed that he is available tomorrow. Then we'll go to Mr. DeSalen, and then we'll talk. Thank you.